not seeking, that is.
Okay, okay.
That's why I pray for listing of the Archon FAU tomorrow, Lordship, along with the injunction application.
Okay.
May I please, Lordship? Third, I beg to mention item number 6, my lord, with the consent of the other side. But this matter may be taken up after vacation, my lord. Other
After?
side is item number 6, my lord.
Yes.
Lordship, a date may be fixed, Lordship, because it's an old matter. Lordship.
Heard, Mr. What is the name?
T. Sheikh, my lord.
T. Sheikh, learned counsel for the appellant who
Yes, ma'am.
prays for an adjournment
Fine.
on the ground of personal difficulty
My senior is not waiting.
of the conducting counsel. Miss, what is your name?
Yes.
S.
My name is not reflected in the.
Mrs. Kanungo, learned counsel for the respondent does not oppose the prayer. Hence the prayer is allowed. Let this matter be listed in the 4th week of January on a date to be fixed by registry.
Okay.
State.
Fourth week. We have vacations, many vacations.
Hello.
Your Lordship, I beg to mention item number 9. I've taken consent from the other side, Your Lordship. The matter may be taken up after vacations.
Why you are seeking adjournment?
Senior Mr. R.K. Bhatra is not in town, Your Lordship.
Heard Miss
A.B.
Abiani, learned counsel for the appellant who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. She submits that she has informed the learned counsel for the respondent regarding her prayer for adjournment, and they have no objection to her prayer. Stop. The prayer is accordingly allowed.
May I please? I pray for listing upon CRP IO for admission in the next week, any date, my lord. This matter relates to maintenance. And my lord, the maintenance is given to the wife, but the husband is not paying and his man, my lord, retirement due
In the next week, when you want,
Monday or Tuesday, any date.
Tuesday.
Tuesday. Okay.
May it be pleasure, Lordship. Lordship, with the consent of the other side, I beg to mention item number 7 and 8 of daily list. Lordship, my senior has some personal difficulties. So matter may be adjourned for the day and fix it on 27th of January.
No fixed date. Heard, Miss, what is your name? M. Kolita, learned counsel for
For the respondent.
learned counsel for the respondent who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. She submits that she has informed the learned counsel for the appellant regarding her prayer, who has no objection to the same. The prayer is accordingly allowed. Let this matter be listed in the 5th week of January on a date to be fixed by registry. January 2026.
May I please do Lordship, I beg to mention for listing on MSC appeal, Lordship, fresh matter, Lordship.
Fresh matter, next week.
May it please, your lordship. I beg to mention for listing of a transfer application, my lord. We have filed it yesterday. It may come up on Monday, my lord.
It will automatically be listed on Monday.
Yet, my lord.
No, this is wrong practice of filing and mentioning. If it does not get listed on Monday, then you mention.
Obliged. May it please, your lord. Your lordship, I beg to mention for listing an early hearing regarding pertaining to RFA matter, lordship. It was supposed to come in this week, lordship, but it's not listed. It will be listed on tomorrow, lordship.
Okay.
May it please, your Lordship. I beg to mention, Lordship, listing for a MSC appeal, Lordship. It's a long pending case, 2019.
Listing for hearing.
Yes, Lordship. Next week, Lordship.
Hearing next week is the motion week.
Immediately after vacation.
Okay, in the 1st week of January.
Date may fix, Lordship.
Date to be on a date to be fixed by registry.
Item number 1.
Yes.
May I please, your lordship? May I please, your lordship? My lord, the 483 application, my lord. FIR at page 16, my lord. There's a commercial quantity, my lord. And I am behind the wall for
For how many days?
my lord, we are arrested on 4/4/2024, my lord. More than 6 months, my lord. We are behind the wall.
2024 or 5?
25. 4/4/2025, my lord. And another is 28/5/2025.
What is your ground?
My lord, my ground is that, my lord, section 37 is there, my lord. So, one ground, there are two twin points, twin grounds is there, my lord. That one is, that opportunity should be given to the prosecutor that has been complied with, my lord.
That?
That has been complied with because my lord, the learned PP has received the copy. And he is here. And another point is that, my lord, that whether my lord, that formation of opinion as to whether there is reasonable grounds to believe that the accused are not guilty. So to consider this matter, this point, my lord, we have go to the FIR and evidences, my lord. My lord, kindly see the FIR first. Whether in the prima facie, my lord, whether the accused are guilty or not. If in prima facie it is doubt that they may not be guilty, my lord, then we will may get the benefit, my lord. But may I read the FIR? The FIR prima facie says, my
What is the name of the accused?
lord, the accused, my lord, there are 3 petitioners, my lord. One is Mojibur Ali, my lord, another is Kabil Ali, and San Muhammad, my lord, Muhammad San. The contraband were recovered
The
from
petitioners are Kabil Ali, Mujibur Ali and
Muhammad San. Muhammad San's name is not in the FIR, my lord.
okay.
His name it is not in the FIR. As per FIR, my lord, it is the case 16, my lord. In the FIR, it is prima facie doubtful whether the contraband were recovered from my possession, whether it was in the conscious
Is
possession.
there, is there.
And copy, lordship.
Charge sheeted case.
5 witnesses have so far been examined.
5 witnesses
Five
have been.
Eyewitnesses have been examined. And
Out
we
of
have
10. Out of 10, lordship.
and there are many contradictions, my lord. It is seen,
No, those questions we cannot go into now.
my lord. First of all, my lord, may I read the FIR 2 para? Then it will be clear. my lord.
Yes, yes.
With reference to the subject cited above, I would like to inform you that today on so and so information was received from reliable sources at 12:05 AM that 2 persons, namely Mojibur Ali and Kabil Ali of so and so village, were in possession of a huge number of drugs tablets in their house, given to them for sale by Purva Serva, is one of the accused. He has been arrested, my of the same locality, which were to be sold in the early morning. Accordingly, the GD&T number so and so. Now, my lord, at the bottom of the FIR at page 16, on the same page, bottom paragraph, my lord. After that, the team entered the house premises of both accused, which were within the same boundary. The police personnel offered a personal body search, and both accused were served notice under section 50 of NDPS. The search was first conducted in the house of Kabil Ali, son of so and so, resident of so and so, and then the other parts of the and followed by Mojibur Ali, as about 23 years, and then other parts of the premises. First of all, my lord, the house where it was searched in the house, my lord. Nothing was found. There, then next paragraph, my lord. During the search, one Morapat bag was found concealed near the boundary wall of the house, within the boundary covered within tin sheets. Inside the Morapat bag, there was a blue Puma school bag, which contained a large black polythene carry bag with 16 small plastic carry bag inside, containing suspected NDPS substances. Then, my lord, here, then next paragraph, my lord, description of the seizure, then next para. After that, the accused were interrogated on the spot, where accused Mujibur Ali revealed in front of the witness that the capsules were given to him by Furpa Sherpa. He's according to the FIR, here says that the contraband were given to him by one Furpa Sherpa, son of so and so. He was also apprehended from his house. Now, my lord, my question is that those contraband were not recovered from the house. They were recovered from the boundary. Now, the question is that whether there is a boundary wall and gate is there. It is 12:30 AM at night. The police says, and the FIR says that the contraband were not found in the house. And this contraband were found in the boundary, near the boundary wall, within the boundary. Now, my lord, if there is a boundary, there may be a gate, my lord. Then how the police entered into the house? Maybe call to the accused persons, then he will open the gate and allow them to enter the house. Then search may be conducted. This part is not there. That whether how they entered the house, my lord, whether they jumped over the boundary wall. That means, my lord, my submission is that there was no boundary wall. One side is boundary wall in the case diary or the evidences. It is come. Only one side boundary is there. That is the Bhutan border, my lord. This house is near the Bhutan border. One side boundary is there and three sides were open. Mujibur Ali and Kabil Ali, my lord, they stay in the same house, in the same campus, but the different house, my lord, on the same campus, my lord. So this contraband were recovered from the boundary. So the ground is that this contraband were recovered not from the conscious possession of the petitioners, my lord, because these were not found from their house. It was found from the abandoned area. Now, my lord, I will kindly may peruse, my lord, PWs. What does the PW says? How this contraband were recovered? Their statement is there, my lord. 5 numbers of witnesses has been examined. What does they say, my lord? Whether there is contradiction, my lord. Whether we can believe that the accused person may not be done the offense, my lord.
No, we cannot conduct a trial at this stage.
Well, so from the
Why?
prima facie, my lord, as the prima facie, we can understand that whether they are guilty or not. From this part, we can say, my lord, primarily we can say that that contraband may be kept by someone else, my lord, in the boundary, because these two are not found from my possession, physical possession. At night, my lord, some person informed the police. Police came at night, my lord, and the contraband were found. Who show the contraband? Police searched the house, nothing found. Then searched the other part of the campus, my lord, nothing found. 2 witnesses, my lord, they show that they removed the tin and show that these are the contraband, my lord. Then we can doubt that this contraband may be planted by some other persons, my lord, because these contraband were not found from the conscious possession from the petitioner, my lord. Thereafter, my lord. So I want to show, my lord, that page 34. Page 34, my lord. The informant, this is the one of the witness, my lord, who went to church with the police, my lord. What they say? Para number 3, my lord. Page number 34, para 3, evidence, my lord. At 12:30 AM, we reached the house of the accused Kabil Ali and Mujibur Ali. Thereafter, IC Darangamala outpost conducted search of our body through the independent witness. Thereafter, room of accused Kabil Ali was searched.
Page.
Page 34, my lord. Page 34, para number 3.
Yes.
Page 34, para number 3. At 12:30 AM, we reached the house of the accused Kabil Ali and Mujibur Ali. Thereafter, IC Darangamala outpost conducted search of our body through the independent witness. Thereafter, room of accused Kabil Ali was searched, but did not find any items in his room. And then we made search in the room of accused Mujibur Ali, but did not find any items. Both Kabil Ali and Mujibur Ali are stay in the same house. Number 5. Thereafter, we made search.
Is this your first bail application?
This is the in the trial court. It helps. One time it is rejected, my lord.
Where is the rejection order?
Rejection order at page 56, my lord.
Hmm.
Accused Purva Sharma, Mohammed San, Kabil Ali and Mujibur Ali. And relevant portion, my lord. Page 57, second para from the bottom. That the prayer for bail is hereby rejected, my lord. Last para. My lord, in the 5 witnesses examined, and another ground for petitioner number 3, my lord. His name is nowhere involved in this case, my lord. Only, my lord, the police has arrested me on the ground that petitioner number 3 is a shopkeeper. He has a stall of mobile parts, my lord, accessories, mobile accessories. And petitioner number 2 purchased some mobile accessories from me and he transacted rupees 1,500. And from this clue, my lord, arrested petitioner number 3 that he may have the connection with this offense, my lord. Otherwise, his name is not in the FIR. And in the forwarding report, my lord, kindly see the forwarding report. Is the copy
In the
paste.
charge sheet, what was the ground against petitioner number 3? Mohammed Shah. Petitioner number 3 is Chan Mia.
It's Mohammed San, my lord.
His bail application was earlier rejected by this court.
It was not rejected, Lordship. Direction was given to approach the trial court
Trial.
because charge sheet was submitted. So
Okay.
My lord. The ground,
Then you appeared before the trial court.
my lord, appeared, my lord.
whether that order would amount to disposing of the matter, Lordship, because I will give to your Lordship.
My lord, appeared, my lord. Accused Mohammed Sant and further considering the nature of offense, which is under section 22C of the NDPS Act, the prayer for bail is hereby rejected. It was on order was 18/9/2025.
Okay.
The ground of arrest of petitioner number 3 is in the forwarding report. We can see from the forwarding report, the ground of arrest. Ground of arrest number 1
Page number?
is number 20. The other parts, my lord, is same as the ground of forwarding report of accused number 1 and 2. Is the copy paste. And only ground of arrest number 1 during re-interrogation of accused Purva Sherpa, he is the accused, in Nalbari jail, he disclosed the name of main supplier Mohammed Chan, who supplied him, and Mujibur Ali, the seized so and so numbers of psychotropic tablets in commercial quantity. My lord, there is a contradiction. In the forwarding report of accused number 1 and 2, and the FIR, and the evidences also, it has come that Purva Sherpa gave the contraband to Mujibur Ali and Kabil Ali to sold in the morning. But here in this forwarding report of accused number 2 says that this
Page number, forwarding report is
is number 20,
20.
my lord. Page number 20. Ground of arrest number 1. During re-interrogation, the accused Purva Sherpa in Nalbari jail, he disclosed the name of main supplier, Mohammed Chan, who supplied him,
No, it
And-
was at the stage of investigation.
my lord, at the
He
time
was
of
arrested.
investigation, my lord.
Thereafter, during investigation, materials were found against you. Therefore, charge sheet was laid. Is it a case, is
Yes,
it
ma'am.
your case that no materials are there against
No, well, there are
Chan?
contradiction. The
Contradiction?
contradiction found in the open space of the boundary. That is one that there may believe that
Some witness stated in a particular way, some witness contradicted that. Now it is for the trial court to believe which witness.
police has contradicted that once they say that Purva Sherpa gave the contraband to Mujibur and Kabil. And thereafter they says in the forwarding report that the San Muhammad, the petitioner number 3, gave the contraband to them to sell. So these are the contraband. Who gave the contraband to whom to sold? This is the question, my lord. So there is doubt, there is suspicion. And at the stage of bail, my lord, one suspicion, one doubt is sufficient for grant of bail, my lord.
No.
My lord, there-
Anything else?
my lord, from the evidences, my lord, may I peruse, my lord, the evidence?
Yes.
From the evidence of PW1, we have read para number 3, then we read para number 4, my lord. Para number 4, we have read that the contraband were
Page number
found.
to go to. Page number.
Page number 35, my lord.
Yes.
Page number 35. Thereafter, room of accused Kabil Ali was searched but did not find any items in his room. And then we made search in the room of accused Mujibur Ali but did not find any items. Both Kabil Ali and Mujibur Ali staying in the same house. Thereafter, we made search in a scooty, but nothing was recovered in the scooty. Thereafter, along with the independent witness, we made search in the boundary of the house of the accused Kabil Ali and Mujibur Ali. And when the independent witness removed one tin during search operation, we noticed one gunny bag. Thereafter, in presence of all, the gunny bag was opened. When gunny bag was opened, we found one bag with name Puma school bag, and when the said Puma school bag was opened, we recovered 16 numbers of black carry bag. So here, in the house, nothing found. In the scooty, nothing found. Police did not recover. But two witness, they went to the abandoned area and removed the tin and found the gunny bag. So it suspects that this person or may other person in connivance may keep the contraband and drag them into the case, my lord. This is a serious nature of case, my lord. They are behind the bar. Otherwise, at 12, if the police personnel entered into the house by opening the gate, as per the statement of the police, then there was the chance to escape through the back door, but they have not done that. They cooperate with the search, and nothing was found in the house. These contraband are not found, recovered from the conscious possession. So that is the ground, my lord. This contraband are not recovered from the conscious possession, my. It was at 12. The police search, two independent witness saw the contraband in abandoned area. And my lord, 5 numbers of witnesses have already been examined. And my lord, there is no other antecedent, criminal antecedent is there, my lord. This is the first one, the alleged first one, my lord. And we will cooperate with the investigation, my lord. We are the local people, my lord. We will cooperate with the investigation, my lord. And in this regard, my lord, I will submit one very small judgment of Honorable Supreme Court, my lord. In this judgment, my lord, kindly may peruse para 4, my lord. I will read the para 4, my lord. As regard to the twin conditions contained in section 37 of the NDPS Act, learned counsel for the respondent state has been duly heard. Thus, the first condition stands complied with. First is complied with, that means the PP, learned PP was there at the time of hearing. So far as the second number condition are a formation of opinion as to whether there are reasonable grounds to believe that the petitioner is not guilty. The same may not be formed at this stage when he has already spent more than 3.5 years in custody. The prolonged incarceration generally militates against the most precious fundamental right granted under Article
No,
21
but in
of the
this case,
Constitution.
the emphasis on prolonged incarceration. And you have spent only not more than
And-
8 months. So this is not applicable.
My lord, the prolonged incarceration generally militates against the most precious fundamental rights. So and so.
How long you are behind the bars?
Behind the bar for about 8 months, my lord. However, the case is 5 numbers of witnesses are examined and total 19 numbers of witnesses are there. It will take more time, my lord. And more,
8 months cannot be regarded as prolonged incarceration in commercial
the-
case.
so far the
The
material.
case which you are citing, the incarceration was for 3.5 years.
Therefore, my lord, the court has said that at this stage, it is difficult to say that whether they are guilty or not. But even the bail was granted, my lord. Then my humble submission is that whether there is any criminal antecedent. My lord. Against the Furpa Serpa, my lord, who is the accused, he is in jail. Against him, my lord, some cases are there. But against these three persons, my lord, there was no any criminal antecedent. As the local person, they will cooperate with the investigation, the trial. My lord.
Yes, Mr.
Here, if I'm not wrong, Lordship, they are behind custody for 251 days, subject to correction. In respect of petitioner 1 and 2, Lordship. 3 was arrested subsequently, 28/5. So it will be little lesser. I have not done the calculation in respect of petitioner number 3, Lordship. Only in respect to 1 and 2, Lordship. Now, Lordship, here, charge sheet was submitted on 6/6/25. And Lordship, charges were framed on 14/7/25. In respect of petitioner number 1 and 2 under 22C, 25 and 29. And in respect of the present petitioner, petitioner number 3, Mohammed Chand, 22C and 29.
Yes.
And Lordship, there are altogether 10 PWs. 5 have been examined so far. He has already taken your Lordship to PW1. Lordship, PW.
What are the materials against
Yes,
third petition?
third petitioner. Third petitioner, Lordship will kindly come to this forwarding. Page 20. And I will take your Lordship to one particular PW.
Page 20.
Page 20. This is the forwarding, Lordship.
Yes.
Here, Lordship will see grounds of arrest. Point number 2. Mohammed Chand's involvement in supplying the illegal psychotropic substance to accused Mujibur Ali has been well established through CDR of accused Mujibur Ali, mobile number so and so, who had communicated with him 7 times from his mobile number to Chand at his mobile number so and so as per CDR data. Number 3, accused Mohammed Chand's mobile handset along with activated SIM card so and so was seized from his possession so and so. And these are the 2. Now, Lordship, in the kindly Lordship will take up the scan copy for a moment. The second flag, Lordship will kindly see. That witness has not yet been examined. She is a charge-sheeted witness, Lordship. LW6. Second flag, Lordship. Nazia Khatun.
Yes.
Yes, this is the wife of Lordship Mujibur Ali. She is yet to be examined. This is her 161 state.
She has implicated all of.
She
She
is
is
the wife
the
of
wife,
Mujibur.
my lord.
Whatever,
Definitely.
Lordship, she is a prosecution witness, Lordship. And Lordship, she has not been examined so far, Lordship. But that is the material. So Lordship, here Lordship will kindly see evidence is going at a rapid pace. Already 5 PWs have been examined. That is the case, Lordship. And Lordship, regarding the possession part, Lordship, it was recovered from the within the campus, Lordship, of the petitioner's house. PW4, Lordship, is another independent witness, Lordship. His deposition is before your Lordship. His categorically stated the same.
Okay. Heard. Anything else?
No, no.
Heard Mr. A.K. Azad, learned counsel for the petitioner. Also heard Mr. B. Sharma, Learned Additional Public Prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioners, namely Muzibur Ali, number 2 Kabil Ali, and Muhammad Chan, who are detained behind the bars in connection with special NDPS case number 11/2025, arising out of Kamalpur PS case number 92/2025 under section 22C/25/29 of the NDPS Act 1985. Stop. The petitioner number 1 and 2 are detained behind the bars since 4/4/25, whereas, petitioner number 3 has been detained behind the bars
28.
since 28/5/2025. The gist of accusation in this case is that on 4/4/2025, one Mohendra Soikia, SI of police, had filed and had lodged an FIR before the officer in charge of Tamulpur police station, inter alia, alleging that on that day, an information was received through reliable sources that 2 persons, namely Muzibur Ali and Kabil Ali, within bracket petitioner number 1 and 2, were possessing large number of suspected drugs, prohibited drugs in their house, which was given to them by one Purba Sherpa for Purba Sherpa. Stop. Accordingly, a search team was constituted and a search was made in the house and premises of the petitioner number 1 and 2 in presence of independent witnesses. Stop. Though nothing was found from the inside the house of the petitioners, however, during search operation, a gunny bag was found concealed near the boundary wall under the tin sheets. Stop. On removing the tin sheets, and searching the gunny bag, it was found that there was a blue color school bag wherein a black color polythene was there containing 16 small plastic carry packs containing what was the contraband? What capsules? Containing,
Exactly, the name of the capsules are not there.
what was this?
Psychotropic tablets are mentioned.
No, what is the forensic report? Containing 1388.67 grams of suspected narcotic drugs. The petitioner number 1 and 2 were arrested from the
Tramadol capsule. Tramadol. FSL report opine. Tramadol.
from arrested from the place of search. And during investigation, involvement of petitioner number 3 was also found. Stop. It is also found during forensic examination that the recovered suspected narcotic drugs contain tramadol, which is a prohibited narcotic substance under NDPS Act 1985. Learned counsel for the petitioner has submitted that the petitioners are innocent and have been wrongly implicated in the case. He submits that nothing was found from the residence of, from the house of the petitioner number 1 and 2, and the suspected narcotic substance was recovered only near the boundary wall of the boundary of the house of the petitioner number 1 and 2. He submits that the circumstances under which the narcotic substance was recovered cannot rule out a third person or somebody else keeping the narcotic substance there in the boundary of the house complex of the petitioner to implicate the petitioners falsely. He further submits that the petitioner number 3 is not even named in the FIR, and he has been implicated merely on the basis of the statement of the co-accused. He further submits that in the meanwhile, 5 out of 10 prosecution witnesses have been examined, and there is contradiction between
amongst the
and
witnesses' mind.
there are material contradictions in the testimony of the witnesses which would give benefit to the petitioners. He further submits that the petitioners are languishing behind the bars for more than 8 months, and 5 more witnesses are there to be examined, and it is unlikely that the same would be done very soon, and therefore he submits that petitioners are entitled to get bail. He also submits that since a reasonable suspicion arises regarding involvement of petitioners in the alleged offense on the basis of the witnesses which are already examined, an opinion may be formed that there are reasonable grounds to believe that petitioners are not guilty of the offense alleged against them. He further submits that the petitioners are also entitled to get benefit of bail on the ground of prolonged incarceration, since they are detained behind the bars for more than 8 months, and trial has not yet been culminated. In support of his submission, he has cited the ruling of the apex court in the case of Ravi Prakash versus State of Orissa, reported in 2023, 0 Supreme within bracket SC 707. On the other hand, learned additional public prosecutor Mr. B. Sharma has vehemently opposed the grant of bail to the petitioners on the ground that the quantity of contraband recovered in this case is of commercial quantity, and therefore embargo of section 37 of the NDPS Act is applicable to this case. He submits that the materials on record clearly shows that the contraband was recovered from the within the boundary of the residential complex of the petitioner number 1 and 2, and the manner in which it was kept concealed leaves no doubt regarding their involvement. He further submits that though petitioner number 3, though nothing was recovered from the possession of petitioner number 3, during investigation, his involvement under section 29/22C of the NDPS Act has also been established on the basis of CDR report and statement of other independent witnesses. He further submits that wife of the
Mujibur,
petitioner number
1,
who has implicated all the petitioners in her statement, which was recorded under section 180 of the BNSS, is yet to be examined. And therefore, on the basis of only 5 witnesses recorded by the prosecution side, at this stage, he submits that an opinion regarding innocence of the petitioner may not be formed. He therefore prays for rejecting the bail application. I have considered the submissions made by learned counsel for both sides. Undisputedly, the quantity of contraband recovered in this case is of commercial quantity, and therefore, to get the benefit of bail, the petitioners have to overcome the twin embargo contained in section 37 of the NDPS Act. This court has to arrive at a opinion that there are reasonable grounds to believe that the petitioners are not guilty of the offense alleged against them. And only in such an event, they may be granted bail. In this case, as it involves recovery of commercial quantity of contraband. However, from the materials on record, it appears that there is evidence to indicate that the recovered contraband, that the contraband involved in this case was recovered from within the boundary of the residential complex of the petitioner number 1 and 2. And therefore, at this stage, it may not be possible to form an opinion regarding existence of reasonable ground to believe that they are not guilty. Stop. As regards petitioner number 3 is concerned, the 5 remaining witnesses who are one of the 5 remaining witnesses who are yet to be examined have implicated him in connection with the alleged offense. Stop. The PDR reports as well as other materials also points to his involvement regarding the alleged offense. Points towards his involvement under section 29/22C of the NDPS Act in this case. Further, though this court is in agreement that prolonged incarceration agreement with this court does not dispute the proposition of law that prolonged incarceration overrides the embargo of section 37 of the NDPS Act. However, for that, the incarceration undergone by the petitioners have to be considered to be long enough by the court. Stop. Since huge quantity of suspected prohibited drugs were recovered from the possession of the petitioners, the incarceration presently undergone by the petitioner, that is about 8 months, in view of the fact that the trial is proceeding smoothly and already 5 witnesses have been examined, does not seem to be long enough to give benefit of bail to the petitioners on the ground of prolonged incarceration. Stop. For the reasons stated herein above, this court is reluctant to grant bail to the petitioner at this stage. The bail application is accordingly dismissed.
Highly obliged, ma'am.
May I please, Your Lordship? Lordship, as per the previous order of the Honorable Court, Lordship, we had issued notice upon the opposite party by speed post. Lordship.
I have received the instruction to appear on behalf of the respondent, Lordship. By today, I will file my wakalatnama. So Lordship may fix it any day after vacation, Lordship. And they may be directed to furnish a copy of that memo, Lordship.
Miss, what is your name?
Lordship PJ Das.
Heard Mr. P.J. Das, learned counsel for the petitioner. Also heard Mr. A. Ahmed, learned counsel who submits that he has been instructed by the respondent to appear in this case, and he would be filing his wakalatnama during the course of the day. He also prays for directing the petitioner to furnish a copy of transfer application along with the transfer petition along with the annexures to him. You furnish it. The petitioner is directed to do so during the course of the day. Release this matter again after winter vacation. Release this matter again on 9th of January.
Obliged.
Although my name is appearing in the respondent side, but we don't have any contact with the respondent since 2013. The matter was listed after 2013, it was listed in 2022. And that also, they have not contacted us. May I pray this, just give an opportunity to give a notice. I will send a notice to them. If they appear, then it's okay. Otherwise, your lordship will hear a ex parte.
Lordship, on the last occasion as well, they failed to appear, and this is a 2013.
That's what I am
second-
submitting. We have no instruction since 2015, when earlier
No,
council. had
but
been-
when the brief is with you,
No, it's not with us. It was earlier handled by my Lord Justice Suman Sham. And after his elevation, the clients have not contacted us. After 2013, it came for only on 2022.
okay, we'll give a fixed date.
Yes, madam.
The
I
last
will just
opportunity.
issue a notice and,
Otherwise, it will proceed expert.
yes,
A
definitely.
last opportunity. grant.
That's what I am submitting.
Heard Miss
V. Rai on behalf of Mr.
B,
SK.
B,
V. Rai.
V. Rai, learned counsel for the appellant. Also heard Mr. A. Das,
Third.
A. Dhar, learned counsel for the respondent, who submits that he does not have any contact with the respondent since
2015.
2015, and therefore he submits that he may be granted some time to what you
I
intend
will give a notice to them, issue a notice to them,
for withdrawal.
because otherwise my name will be shown.
Whether brief is with you or not.
No. Because I don't know what happened after 2015. They have not contacted me. Because from the same chamber, it came.
Key last line. No, continue. He also submits that the respondent has not also contacted him after 2015. Therefore, he may not, he is inclined to, he intend to withdraw from this case, and some time may be granted so that he may give notice of the said fact to the respondent. The prayer is allowed. Let this matter be listed again,
Shoot, borrow.
again in the 5th week of January on a date to be fixed by registry. It is hereby made clear that considering the whole pendency of this case, no further indulgence shall be granted to the respondent side.
Obliged.
Highly obliged.
Item 4.
Right, please, your lord. With his permission, my lord, permission of my senior panel. No, I do not give any permission, my lord.
No,
Concerning this case, your
No,
lord,
let me-
you may kindly see, my lord, the order passed during the month of September. The respondents, my
My lord,
lord,
let me-
appeared that they are not interested, my lord, to present their cases. And they take various, please, your lordship may kindly see, my lord, I am coming from Delhi, your lordship, and for how long I should come, my lord, from.
No, we don't know what he is
You are
going
good
to
at-
say.
Let me
No.
conclude my part, your lord.
No, let him submit what he want to say.
Permission to speak out something.
What you want to say?
My lord, today itself, my lord, we have filed the Bhogalatnama. Morning client has come. Earlier, Mr. Bhubaneswar Kalita, senior advocate, he appeared. And my lord, from September, my junior, my lord, made a contact with the client. Could not contact. Yesterday evening, they informed him that we have come and with Bhogalatnama. Today morning, my lord, we have filed our Bhogalatnama. So we are, my lord, totally in handicap. And I can at the same time, my lord, I'm sorry for the inconvenience to my senior friend. My lord. And we also made a contact, my lord, over his phone, but we could not contact him because he was at the point in Delhi.
2015 case.
I understand, my lord.
Your lordship may kindly see the, my lord, order passed during the month of September when I came from Delhi, your lord.
At that point in time, I was
The
not
same
there.
plea, my lord.
That was a different set of lawyers.
Yes.
But decided the matter would be taken up during the month of December, your lordship. And accordingly, I had to come, your lordship. Now again, my lord. So, my lord, my submission is that, my lord, let me conclude this part. If they had to say, my lord, anything, let them say on Tuesday, your lordship. I will be there up to 19. It will be part of your lordship. Otherwise, my lord, this case is not going to be, my lord, disposed of, your lordship. In this way, it will go, my lord.
My friend can also take the, my lord, advantage of
Let
virtual
me
court from
conclude my
Delhi.
part, your lord.
No, Mr. Purkasta. We
Correct.
can start hearing. You reply on some other day.
My lord, that may not be, my lord,
You have not gone through the brief.
exactly, my lord. Today morning they have come. And yesterday also, my friend, my lord, contact Mr. Taj in the evening, I think.
Lord, the junior remains the same, your lordship, only the. senior
Then we
person
will
has
fix
come.
it on Thursday.
Thursday, my lord, during
You go through the brief.
entire brief, my lord, is a voluminous brief, my lord.
May I
It-
The other day I received an additional affidavit on September. Supplementary affidavit in September I received it. Matter is so old matter. Then I had to contact my clients because I was there when we filed our cover along with our senior advocate. Subsequently, I was not in the case. On the last occasion, I was in court, yes, since my name is there, so I had to appear. I then issued this formal code that yes, I will make a contact. And on that day, I received this affidavit again, a supplementary one. Then I have to contact them and to get the information instruction in that regard. Yesterday night they came, I tried to contact him. And he told, yes, today I'm coming here and I concluded my senior. As per the instruction, I'm to engage once. This is my, at this juncture, may I submit that?
No, unless we give Mr. Purkasta a chance, he may not be able to assist the court properly.
Exactly. So, my lord, I will be grateful to him, my lord, if he is going to accommodate us. And for the
My lord,
convenience of the
That's
court,
why, my lord, if he is not, my lord, that's why I am saying, my lord, let me conclude my part, or my lord, let the case again come listed on Tuesday next year, lord.
Tuesday is the,
Tuesday is the holiday, no?
Today is
next week is the
Thursday.
motion week.
Motion.
My lord, if your
So
lordship,
it-
that's the part.
It's a voluminous
It is
record in
special,
history.
my lord, favor to me, your lordship, because my lord, about 3-4 days I have had to come for this.
And
case.
he is, my lord, doing
And
city.
every time, my lord, there was a plea like that, your lord.
No, every time, no,
only
this is
last
for the first
occasion I
time.
could appear. Only last occasion was all the
I do not know
Last
what
one I
about
could appear.
whoever the advocate, my lord,
No, no, no.
whoever the advocate.
Whenever you're submitting.
Your lordship will see so many occasions it was listed for hearing.
On 18th,
Huh.
18th of December.
18th of December, whether it will be possible.
We'll see, we'll see.
My lord, problem about.
We don't.
And matter is simple. Matter is simple.
They lost the case in
My
both the
lord,
courts.
I will argue, matter is simple. suit was dismissed on res judicata, your lordship, and court had passed an order to, my lord, furnish the, my lord, details regarding the earlier suit that I have furnished, which shows that, my lord.
Lord Mr. N. Dhar, learned counsel for the appellant. Also Mr. A.K. Purkayastha, learned counsel for the respondent, who prays for an adjournment on the ground that he has been engaged recently by the respondent in this case and has filed his wakalatnama today only and has not gone through the brief and needs some time for going through the brief before he makes his submission in this case. Stop. On perusal of the record, it appears that this is an old pending regular second appeal of the year 2015. And on last occasion also, adjournment was granted on the prayer of the respondent side only. Stop. However, considering the submissions made by Mr. Purkayastha, the hearing is adjourned for the day, for today. Let this matter be listed as a fixed item on 18th.
After this vacation part. If it's there is why, because I'm not able to contact him and.
Mr. Purkayastha would be there.
I will, cannot be able without it.
Then it will go ex parte, your lord.
No, no, no.
If that is the attitude, your lordship, it will proceed ex parte, your lord.
No.
Because I submitted the other day, I submitted that I would contact my client because there was no contact for last 4-5 years. Since
8th of January. 8th of January. Unless we get their assistance. 8th of January.
8th of, my lord,
January.
will be going back by 20th, your lord.
We will not be coming again anytime.
I will be coming during the month of March, and my problem is that, my lord, this, my client, my lord, the appellant, he is 90 years. And he has to, my lord, always, my lord, asking me to manage this thing, my lord, before he is departing from this earth, your lord. What? It is my problem, your lord.
So far as his problem is concerned, I have fully, my lord, agree with him, my lord. I have full sympathy. The only problem is that, my lord,
Once
unless and until I
Honorable
get.
Mr. Justice, my lord,
Okay. No, this is a very old pending case.
I understand. my lord.
And on last occasion also you prayed for an adjournment.
if they are not
Yeah.
available,
That was the ground, and according like short term, yes, I would
let
contact.
it be on
So
16.
registry was supposed to contact them. So that was
Let it be on
situation. as such.
16, my lord, then
Otherwise,
if on 18 they are out, then let it be on 16, it is also a hearing day.
I'm not there since my own engagement, so 15 onwards. So I'm very sorry to say that you can only engage.
This is the thing, your lord. This,
That may be on, it's a, we confuse them. That I'll be there.
8th of January.
I will not be there.
You may attend through VC, video conferencing.
Once Mr. my lord, Honorable Mr. Justice, my lord, Burua, he told me that you may not be coming from Delhi for this case. I say that I will have to come because, my lord, some social responsibilities there. He is an old man, and furthermore, he was a teacher, my lord. So, my lord, out of these sorts of things, my lord, I have to come. Now, my lord, after again and again, my lord, leaving the cases at the apex court, your lordship, it is very difficult to come, your lord. So my submission would be, my lord, let it be on.
Okay, Mr. Purkayastha, you will be here.
I will be here, my lord, without his assistance.
He
my
will
lord,
be here.
I will be here.
And
No,
he is a very competent lawyer.
No,
your
no.
lord.
My lord, second appeal, my lord, it is very difficult to argue the matter, my lord, when he is the advocate.
On 18th. Okay.
18, my lord.
18th will, if required, we'll keep it part heard.
Yes, my lordship, may I keep it as a part heard?
We'll see what happens.
Keep it as part heard,
No,
problem.
no, on 18th,
Otherwise, again, I will have to renew my plan.
18th.
Without his able assistance, my lord, I may not be able to
With
prepare
a
the
peace of
case.
mind, I can go back, my lord, if some reply is to be given, my junior should be there.
Okay, on 18th.
My lord, it
No
may not be
problem, my
possible on my part to argue the matter without his assistance.
Okay, on 18th, we'll see what can be done.
And lordship, may I make an observation the 18th, if my lord, any necessity arises, I will make a prayer for him.
No such observation. Okay,
I apprehend that I may not be able.
let us see.
Please come for this case. Kindly help me also.
I understand.
My request.
18th.
Then lordship,
Okay.
I kindly appreciate that if I am not in a position to argue the matter on 18th, let him argue the matter and lordship keep it as part heard.
We will see, we'll not
My lord.
mention everything about 18
My lord.
today. What I,
My lord.
on 18.
Submission.
Obliged.
For the,
After a long time, your lordship, I am seeing your lordship. Earlier, my lord, your lordship was there, in the civil court, I think.
Yes,
Yes, yes. 86 or something like that,
2004.
2004, my lord. I used to argue my lord before your lordship, I remember that. So many days has passed by, but I had to shift to
You are now stationed at Delhi.
my lord.
You are,
And now, my lord, I had to settle there.
okay. Then we'll meet again on 18th.
Item 5.
Appeal by the plaintiff, lordship. Suit was dismissed. First appellate court affirmed the judgment of the trial.
Just a minute. Yes,
Shall I start, lordship?
both of you are ready?
Yes, my lord.
Yes.
Plaintiff, your lordship will find in page 10, annexure 1, lordship.
Page,
Page 10, lordship.
before you read the plain, tell me the gist. What is
In
the
this
case?
case, lordship, plaintiff is the daughter.
You were the plain.
And plaintiff
plaintiff.
and the daughter, and defendants are 3 brothers. 2 brothers are alive and 1 from legal heirs from another brother, lordship. So
Okay.
they are holding the entire property of my father. The plaintiff's case is that, lordship, earlier she was given D and E schedule, and thereafter they disposed D and E, na? D and E was given to the plaintiff earlier, and thereafter, after death of her mother, she again claiming partition of the property with meets and bounds, as because D and E schedule, she was dispossessed by the defendants. The market rate of the area, lordship, became high, so she was dispossessed from the lands. Earlier, her name was also recorded in the records. as
Then in the suit, what was your
Share, lordship,
prayer?
yes, lordship.
Suit was a partition suit.
Lordship, page 14, your lordship will find there are 5 prayers, a preliminary decree for partition of the property, page 14. In schedule A, B, C, and D, according to the shares of parties passed. A commission for effecting the partition in terms of the preliminary decree be appointed, and in mentioning the share of the plaintiff, the land in schedule D and E be included in her share in effecting the partition. Her claim is that already D and E were earlier given to her. Later on, she was dispossessed. So D and E may be given to her in addition to the rest of the properties. Final decree be passed on the commissioner's report. Cost of the suit be awarded. Any other reliefs as per law equity be awarded. Defendants admitted the lordship that she is the daughter of Muhammad Ali. It was admitted by the defendants. They admitted that D and E was already given to you, so you are not entitled for any further land lordship. And moreover, the
Okay,
defendant.
what was the
Defendants,
judge?
another plea is that lordship, A and B schedule lands are vague lands. There is no such type of lands in the name of Muhammad Ali. But they admitted that D and E schedule already given to plaintiff, and D and E schedule are the part of A and B schedule land lordship. Trial court held that the suit is not maintainable as because there is a no claim for right title interest by the plaintiff in the suit. The suit is barred by section 34 of the specific relief act, lordship. That is one ground. Another ground is that lordship court fee was paid much less than what is required to be paid. Cause of action in favor of the plaintiff, whether the suit is maintainable in present form and manner against the plaintiff. Page 28 are the issues, lordship. Whether plaintiff has paid court fee, that was against the plaintiff. Whether the plaintiff is entitled to any share in the suit land, against the plaintiff. Whether the plaintiff is entitled to partition of suit land, that is also against the plaintiff, lordship. May I read the judgment of the first appellate court, lordship?
Yes, what first appellate court held?
First appellate court held that,
Confirm the decree,
yes.
confirm the
decree.
judgment.
Confirm the judgment. There was no discussion in some of the issues. And only in some of the issues, there is a discussion by the first appellate court. lordship.
What is the substantial question of law which?
That is, lordship. As per Mohammedan law, on lordship will find it is admitted on 31/5/2017. Whether the learned courts below committed wrong in dismissing the suit of the appellant plaintiff on the face of share mentioned under the Mohammedan law for daughters, and that too on the face of the admission that the plaintiff appellant is one of the legal heirs of the predecessor in interest of the parties to the suit. So there is no denial that plaintiff is not the legal heir of the original owner. There is no denial that a share was already given to her. Those facts already admitted, lordship. Number two, whether the judgment and decree passed by both the courts below are perverse, both on appreciation of materials on record and the legal position. Any other substantial question of law that may formulate at the time of hearing.
Yes, now.
First appellate court, lordship, that is at page 58 after issues. I'm reading, lordship. Paragraph 7. In deciding the instant appeal, I have heard argument advanced by both sides and also gone through the judgment of the trial court. On perusal of the judgment, it transpires that the learned court decided all issues and ultimately dismissed the suit. Let me now decide the issue one by one. The trial court, while deciding the issue number 1, considered the pleadings of both parties and also the nature of the issues in controversy. Both parties disputed each other's claim, and the learned court rightly held that there is cause of action for filing of the suit. The decision arrived at the learned court needs no interference, so far as the decision arrived at by learned court as regard issue number 1. It clearly says that it needs no interference, so there is cause of action. Next, the learned court, while decided issue number 2, held that the suit is not maintainable in his present form and manner. The learned court considered the pleading of the plaintiff, where in it was found that though the plaintiff has prayed for partition of the properties left by deceased late Mahmoud Ali, without praying for declaration of her right title, her share, the learned court further held that the law does not permit, if declaration is not sought for without the declaration of her right and title over the suit property, the suit for partition also is not maintainable in view of the bar under section 34 of the specific relief act. Ultimately, the learned trial court held that the suit is not maintainable and the same was decided against the plaintiff. So only the decision which was held by the learned trial court, that was lordship just discussed by the first appellate court, but no Lordship, discussion by the first appellate court itself in respect to this Lordship issue. The learned court, while deciding issue number 3, held that the suit is undervalued. On perusal of the plaint as well as the prayer made in the plaint, it appears that the suit was not properly valued. On this count also, I find no illegality committed by the trial court in deciding the aforesaid issue. So there is no independent discussion by the first appellate court, only the trial court's version was affirmed by the first appellate court. While deciding issue number 4 and 5, the learned trial court decided the issues against the plaintiff. The evidence of the plaintiff clearly shows that she was not sure about the land sought to be partitioned, and she also could not describe the land. The plaintiff is required to prove her case, and she must disclose all the land, including her share in the land left by the deceased. The plaintiff also has to bring all the documents to prove that the land in which the plaintiff has sought her share belongs to her. Further, it appears that the plaintiff could not prove any document to show that her parents have left the properties, and she is one of the co-sharers in respect of her share left by her father. So this is also a perverse finding, Lordship. It is admitted that she is the daughter of late Muhammad Ali, so it is not required to prove, Lordship. Already they admitted. The decision thus arrived at by the learned trial court also cannot be interfered with, as the same has been decided on the basis of the evidence, pleadings, and all other facts. On perusal of the plaintiff, it appears that the plaintiff has filed a suit for partition with the following prayer. Then the prayers were discussed. The plaintiff appellant has claimed partition of her share without seeking declaration of her right and title in respect of the properties sought to be partitioned. The plaintiff did not seek declaration of her right and title, which creates bar on a civil court to give relief to the plaintiff. There is a specific bar under the Assam Land Revenue Regulation 1886, which specifies that the civil court can only declare share of a legal heir and cannot effect partition on its own. In view of Regulation 96 and 97 of the aforesaid Act, the power lies with the concerned revenue authority to effect partition. On this count also, this court cannot grant any relief to the plaintiff appellant, as the same is found not maintainable. Moreover, Section 34 of Specific Relief Act lays down as follows, which is reproduced below. Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief. Provided that no court shall make any such declaration where the plaintiff being able to seek further relief, then a mere declaration of title omits to do so. The provision is very much clear that the civil court cannot declare the right of the plaintiff appellant which was not sought for by her. The plaintiff as appellant has prayed that the suit be remanded back, allowing the plaintiff to amend the plaint to create the formal defect, and also allow the plaintiff appellant to re-examine the witnesses in order to prove the plaint of the plaintiff. The appellant himself admitted that amendment in the original plaint is required to cure the formal defects, but the law does not permit a court to do so. The appellate court, even if holds the view that amendment of the original plaint is required, cannot remand a suit to cure the fatal defects found in the plaint. The civil court cannot partition the properties, as there is a specific bar under Section 97 of the Assam Land and Revenue Regulation. Section 97. The Revenue Authority has the power to partition properties among the co-sharers, and civil court can only declare shares of the
What
parties.
is Section 97?
Lordship, I'm reading. Assam Regulation. Land and Revenue Regulations. The Revenue Authority has the power to partition properties among the co-sharers, and civil court can only declare shares of the parties. So the plaintiff is before the court, Lordship, for declaration of her share only. Right title is not required to be asked by the plaintiff, Lordship, in a suit. The Mohammedan parties are governed by Mohammedan law. Mohammedan law shares are lordship determined. There is no aberrament in the plaint that the plaintiff appellant approached the revenue authorities seeking in
No.
partition.
Whether the defendant denied your right title and interest.
They admitted that I am the daughter of late so-and-so. I have already, I was already given some share. Now I am not entitled for any further share. They did not deny that I am not entitled for share. So my right is there, lordship. As per Mohammedan law, it is implied.
Okay.
The civil court can only declare the share of each of the co-sharers seeking partition. So the first appellate court also held that civil court is competent to declare the share, but in my case, the suit was dismissed only on the ground that I have not asked for title, lordship. But I am asking for share of the plaintiff, lordship, that was not given. Whereas the first appellate court itself held that the civil court can declare share. As the plaintiff appellant did not pray for declaration of her share, the civil court has no power to pass decree of partition. The plaintiff appellant in the appeal primarily prayed for remanding back the suit under Order 41, Rule 27 CPC. This is also a perverse finding, as because there were two petitions were filed by the appellant before the first appellate court. One was praying to remand the suit, and another one was praying to adduce additional evidence, Order 41, Rule 27. An order was passed on both the petitions. I have enclosed with my regular second appeal, lordship. The power of the appellate court to remand a suit can be exercised only under certain circumstances. In the present case, no such circumstance could be found justifying remand of the suit for retrial. To remand a suit for retrial, the appellate court must first reverse the finding or set aside the finding of the learned trial court. In this case, there is nothing to hold that the trial court committed illegality in deciding the suit. Further, the appellate court must hold that proper issues are not framed which justifies remanding the suit to the trial court. In this case, the trial court framed issues on the basis of pleadings before the court. Since the plaintiff did not seek for declaration of her share and right, the issue could not be framed. The issues were framed considering the pleadings of the parties. On this count also, the suit cannot be remanded back to the trial court. Further, the prayer of the appellant to remand the suit for making necessary amendment in the plaint to rectify inherent defect in the plaint also cannot be accepted. The appellate court cannot direct the trial court to allow amendment after remanding the suit for retrial. The amendment is the discretion of the court in which the matter is pending for adjudication. On this count also, the prayer of the appellant cannot be accepted. In views of the discussion and the observation made above, I am constrained to hold that the decision arrived at by the learned trial court while deciding the issue number 4 and 5 also found to be justified, and no illegality or error has been found to have committed by the learned trial court. The decision arrived at by the learned trial court warrants no interference. So only decision 4 and 5, issue 4 and 5 was discussed by the learned first appellate court. And the other issues were affirmed, just affirming the judgment of the learned trial court. There was no independent discussion by the first appellate court in those issues, lordship. The learned trial court, after detailed discussion of the issues, decided the suit and held that the plaintiff is not entitled to any relief. From my discussion, it is amply clear that the plaintiff has failed to prove her case, and hence she is not entitled to any relief as prayed for. The decision so arrived at by learned trial court in deciding issue number 6 deserves no interference. So this is the finding by the learned first appellate court. Now your lordship will find page 62 annexure 5. The order passed in the petitions which were filed by the appellant before the first appellate court. Parties are present through their respective learned counsel. Seen petition number 78615 filed by the appellant under Order 41, Rule 23A read with Rule 57 CPC and Section 151 CPC with a prayer for allowing the appellant to examine additional witnesses in order to prove the original documents relating to the suit land on the ground that appellant is a rustic and illiterate ailing woman for which she could not produce the same in the trial court. The opposite party has filed written objection challenging the claim of the appellant on the ground that during the trial, the appellant has produced documents like Kachapatta, Faraiznama. Faraiznama is the document by which the area of share entitled by a woman is mentioned in the Faraiznama portion. And as such, it is nothing but negligence on the part of the appellant. Copy of the written objection is furnished to the appellant side. Perusal of record further reveals that petition number 13216 with the same contention was filed by the legal heir of the appellant. Copy of the said petition is supplied to the opposite party. Heard both sides on petition number 78615 as well as petition number 13216. Learned counsel for the petitioner appellant has submitted that the above petitions may be heard by this court at the time of final hearing of appeal, but on the other hand, learned counsel for the OP respondent has submitted that the petitions are required to be disposed of at this stage as the same has got no merit. It is pertinent to mention herein that this court is yet to finally hear the parties on the merits of the appeal. Before I go into the merit of the present petitions, I would like to state that the Honorable Supreme Court so-and-so Lordship that such an application under Order 41 Rule 27 regarding Order 41 Rules 27, those were discussed, Lordship, cannot be decided before hearing of the appeal on merit, but it is to be taken only at the time of hearing of the appeal. The same view was subsequently upheld in the case of any railway, Lordship. The next page, Lordship. All these judgments are based on the principle laid down by Privy Council in the case so-and-so. This view has been even followed by Honorable Guwahati High Court in Hadi Hussain versus Safiqul Hussain, so-and-so. Hence, considering the dictate of the Honorable Courts as referred to above, I deem it fit and proper to hear the petitions along with the final hearing of the appeal. So those petitions were Lordship order was passed saying that at the time of hearing, those petitions will be heard. So only finding was given in Order 41 Rule 23 petition. There was no discussion about Order 41.
What is the law?
Order 40.
No. This Order 41 Rule 27 petition
Union
has to be heard.
Lordship 2012 8 SCC 148.
Yes,
It
what
says
it's,
it should be considered at the time of final hearing.
suppose at the time of final hearing, court finds that and that the petition regarding adducing of additional evidence at appellate stage is to be allowed. Then
Sometimes first appellate court takes the evidence itself, and sometimes the appellate court remand it back to the learned trial court to prove those evidence. So far my understanding.
no, thereafter,
Thereafter,
again hearing will be done.
yes, Lordship, it can be
Then
in a regular second appeal here in this case, Order 41 Rule 27 petition was allowed. Finally disposing the regular second appeal and remanded back to the learned first appellate court to take additional evidence on those exhibits, Lordship. Thereafter, again fresh judgment was passed and that judgment is under challenge before this court. And in one of my regular second appeal, Honorable Justice Bujor Barua sir allowed the appellant to adduce additional evidence keeping pending the regular second appeal before this court. And thereafter, the evidence were again called from the first appellate court, and then finally the regular second appeal was decided.
without a fresh judgment by the first appellate court.
Yes, only on the basis of the evidences taken by the first appellate court during pendency of the regular second.
Okay.
So both way that Order 41 Rule 27 can be allowed. The court itself can take evidence, but the regular second appellate stage evidence cannot be adduced. So Supreme Court, High Court remanded back either to the trial court or to the first appellate court by Lordship setting aside the judgments, remanding back, or by keeping the regular second appeal pending to take the fresh additional evidence and then call for the records again, Lordship. In both way, it can be taken up. And Union of India versus Ibrahim 2012 8 SCC 148, it says that the petition cannot be rejected. The petition has to be considered at the time of final hearing of the appeal, Lordship.
Final hearing of the appeal,
Lordship.
and it may be allowed or it may be rejected also at that stage.
Lordship. But a finding should be given at the time of hearing. But this first appellate court, no discussion about order 41 rule 27 petition. Only my petition ordered 41 rule 23 was discussed by the learned first appellate court. Both the petitions also I have enclosed, Lordship. Annexure 7, page 72 is the petition by the legal heir of the plaintiff. He also prayed for reducing additional evidence. And the original plaintiff also filed a petition for remanding, that is page 64, annexure 6, Lordship. A petition under order 41, rule 23A, read with rule 27 CPC. After her death, Lordship, the legal heir also prayed for the same relief. And the entire list of documents also stated along with the.
What is rule 23A?
23A, Lordship, for remand.
Okay. So it was not considered.
No, Lordship, those petitions were not considered. 23A was discussed that it cannot remand on the ground that the appellate court cannot direct the appellant to amend the plaint, Lordship, cannot direct the trial court to amend the plaint, Lordship. But in fact, the prayer was for remanding the suit to the trial court for amending the plaint. Order 41, rule 23A says remand in other cases where the court from whose decree an appeal is preferred has disposed of the case otherwise than on a preliminary point, and the decree is reversed in appeal and retrial is considered necessary, the appellate court shall have the same powers as it has under Rule 23. But my submission is that, Lordship, the substance, I have taken all those ground in my appeal. Your Lordship will find I have stated some grounds in the memo of appeal.
No, but these are not the
Lordship,
substantial question of law which
Substantial
this
question.
court will go into.
Lordship, your Lordship can also formulate, but I am submitting before your Lordship that those are not required as because it is admitted fact that appellant is the daughter of late Muhammad Ali and she has a share. It is admitted by them, Lordship. For that only I was intended to read the plaint, Lordship. Plaint page 12, your Lordship will find paragraph 2. The plaintiff stated that the disease Muhammad Ali Haji, page 12.
Yes. Yes.
The disease Muhammad Ali Haji had owned and possessed the suit land during his lifetime, and he died in 1977, and at the time of death left behind him his heirs such as his wife Sebatan Nessa, since deceased, his sons, that is defendant number 1 and 2, and only daughter, that is the plaintiff, and his another son Sebaruddin, since deceased, who is the ancestor of the defendant numbers 3, 4, 5, 6. So 1, 2, 3, 4, 5, 6 defendants are from the son's side. Plaintiff is from the defendant side. And this fact was admitted by the defendant in their written statement. Page 19, Lordship. Is 20, paragraph 8, Lordship. That the land measuring 40 bigha 3 katha 1 lessa described in schedule A, B, C, and D cannot be treated as suit lands, though the contents of para 2 of the plaint are true. So the genealogy and family tree was admitted by the defendants. and thereafter paragraph 9, that in reply to allegation made in para 3 of the plaint, the defendant state that the shares of the plaintiff and the defendants averred in said paragraph are not correct. The widow of deceased Muhammad Ali Haji got 1/8 share, 7/56 shares. His daughter, that is the plaintiff, got 7/8 share. So they admitted that I am entitled for 7/8 share, Lordship. And each of his 3 sons got 7/8 that into 2/7 shares out of the properties left by late Muhammad Ali Haji. The faraises relied by the plaintiff have no statutory force and the same are also not correct. That the defendants do not admit the allegations made in para 4 of the plaint. It is not true that the plaintiff was entitled to 5 biga 0 katha 7 lesa of land after the death of her father, Muhammad Ali Haji, who had never owned and possessed land measuring 40 biga 3 katha 1 lesa. As alleged by the plaintiff has been possessing more lands than one lands described in Schedule D and E of the plaint. So, Lordship, D and E, they are admitted that already I was given. That the defendant denied the allegations made in para 5 of the plaint, said that her mother died in 1987. It is not true. Plaintiff's mother, Sabatan Nessa, had left 5 biga 8 lesa of land. This allegation is baseless as the plaintiff has not stated specifically the patta or the khotiyan number and dark number with areas of said land and the name of the village in which said alleged lands are situated. Alleged farais number 3 has been manufactured out of nothing, and on the strength of said farais, the plaintiff is entitled to no land. Alleged farais numbers 1, 2, and 3 have no statutory force and the same are baseless, containing properties, lands which are not existed or not left by Muhammad Ali Haji and his wife Sabatan Nessa. The defendants deny the allegations made in para 6 of the plaint. It is baseless allegation that after the death of her mother, the plaintiff became entitled to so-and-so of land of her parental property. The plaintiff has not specifically described the area of land with dag and patta numbers which are recorded in the names of her parents. Such alleged lands, that is imaginary lands, cannot be partitioned. It is not true that plaintiff had approached the defendants from time to time for partition of said imaginary lands, as she is not entitled to get partition of lands as claimed by her. The allegations made in para 7 of the plaint are false and concocted, and the same are denied by the defendants. It is not true that defendants have jointly dispossessed the plaintiff in February 2007 from the lands described in Schedule D and E of the plaint. The claim of plaintiff is baseless and without support of its factum. She has failed to describe specifically the lands alleged to have been left by her parents, namely late Muhammad Ali Haji and late Sabatan Nessa, and such how she would be entitled to partition. So her relation and her share was admitted, but it was said that plaintiff failed to describe the suit properties. That in reply to allegation made in para 8 of the plaint, the defendant state that the plaintiff is not entitled to partition of her shared baseless and imaginary suit land measuring 40
No,
biga.
what is your submission regarding that you have described your ancestral property on some imagination? Which, what was the material to show that this
Okay,
land belongs to your
those
father?
not given. So, Lordship, the additional prayer was made before the first appellate court to adduce those properties. Even, Lordship, the defendants also did not exhibited any document, and in this case, and the plaintiff also did not exhibited any documents.
No, defendant need not to exhibit anything.
Lordship, it is the duty of the plaintiff to prove the documents, Lordship.
You are claiming partition of a plot of land, claiming it to be your ancestral land.
Lordship.
The defendant are raising objection that the land which you are claiming to be ancestral is portion of that land is imaginary land.
But
Then
Lordship,
you have the burden to show that this was your parents' father's land.
But Lordship, already they have admitted that D and E was given to me, and I can show your Lordship that D and E are part of A and B land. Only the fact is that they dispossessed me. That they are denying. They are saying that I am possessing the suit D and E land. Page 14, your lordship will find schedule.
You are claiming partition over which land, schedule A land.
Yes, lordship. A,
Schedule
B, C,
A, B,
D.
and C, madam.
A, B, C, D, separate
Madam,
plot.
there are 5 schedules. A, B, and C, the plaintiff is claiming partition. D and E, it is said that forms part of A and B, and hence while effecting partition, the plaintiff's right may be held in D and E, and she may be given possession there. That was the specific prayer of the plaintiff.
And in addition to D and E, the other layers for other lands for which she is entitled after death of her mother. Earlier, lordship, D and E, after death of father, she got some lands. It is the case of the plaintiff. And after death of mother, she is entitled for more share, lordship. Mother's share will come.
Now the defendant are denying the existence of which land?
They
Madam,
are-
the quantum in A, B, and C are being denied.
Total 20.
C is completely denied. It is stated that in A, the quantum which is mentioned in D and E, what has been stated and what has come out in evidence, my lord, is that is the fact, what has been stated, what has come out in evidence is the fact that a family partition was taken out after the death of the mother, and she has been given a share. What has been asked for by the plaintiff, Basiron Nessa, the lands in A and B, those 2 lands, it is being stated that the contours which have been shown and the area, those are not correct. Those, as such lands are not present there in the name of late Haji Muhammad Ali Haji on the date of his death. And in respect of Schedule C, it has been stated that the said land was given in the share of the brothers, in all share of all the 3 brothers, and the brothers thereafter subsequently sold it. It was gifted by the father to the brothers. So in essence, what has been stated, my lord, in the written statement, what has been contended is not with regard to her right to have a share, but with regard to what properties have been brought in here. That is a burden which has not been discharged in my humble service.
Yes.
Lordship, that they are saying that the lands were already gifted to them and they already sold the entire land to the some other third parties, lordship. We have not made those third parties party in this suit, lordship. That was the ground taken by the defendant, but there was no proof of any gift, lordship. And in fact, lordship, there the DW1 himself admitted that my name was recorded in the revenue record, and those records were, lordship, already.
The trial court as well as first appellate court dismiss your suit claim mainly on the basis that you failed to seek declaration of your right over there.
That is not required, lordship. As per Mohammedan law, lordship,
No,
all the sharers
that
are.
declaration over a particular plot of land. That over this plot of land by way of inheritance in
But
acco-
I have to adduce the properties left by my predecessor, total area, and thereafter my share is determined as per Mohammedan law that wife will
But
get.
when they are denying that this is not the total
Deny,
area,
they have to deny the share of a daughter.
no,
lordship.
they are denying the area of the land over which you are claiming partition.
Lordship, that area will
Suppose
be
the land
determined.
is 1 bigha, the share of your share will be lesser. If it is 5 bigha, share will be more. They are denying that the land which you have included, over which you are claiming your share of as daughter, is portion of that land is imaginary land. It does not exist. So you have the burden to show that this was your parents' land, and over that, by virtue of being a daughter, I have share.
The DW1
And
also.
therefore, trial court and first appellate court dismissed your suit that you failed to seek a declaration over in
That
respect of the property over
which
which
is
you are,
beyond their admission, lordship.
yes, over which you are claiming right of inheritance.
I have to prove that deceased late Muhammad Ali has was the owner of 40 bigha land.
Yes.
That is my duty, but it is not the duty of the plaintiff to claim right title over those part, lordship. As because, lordship, as soon as I am able to prove that 40 bigha was the land of my father, then I am entitled for 1/7 of that plot of land, lordship. The property will be divided into 7 parts, lordship. 3 brothers will take 2 shares each of them, and 1 share will go to the plaintiff. It is determined, lordship. If there is only 7 bigha, then lordship, I am entitled for 1 bigha. If there is only 14 bigha, then I am entitled for 2 bigha, lordship.
So your submission is when the other side has admitted that you are daughter
Lordship.
of late Muhammad
Muhammad Ali.
then a prayer for declaration is not necessary.
As per Mohammedan law, lordship, the sharers are tenants in common. They are, lordship, possessing the lands of their predecessor like a tenant, lordship. And shares are already fixed by the Mohammedan law, lordship. It cannot be changed, lordship. If there are 2 sons and 1 daughter, then it will be divided into 5 parts. The daughter will take 1 part and both the sons will take two parts each, lordship. Here in this case, 3 sons and 1 daughter. So the sons will take 6 parts and daughter will take 1 part. After death of
No,
father and mother.
that is the law.
That is the law, lordship.
Suppose it is accepted that you are entitled to how much share?
1, lordship. In lordship, the sons get double of the share of the daughter, lordship.
Okay, that
In Hindu law, equal share. In Mohammedan law, half of the share of a son.
to that share you are entitled
Yes,
to.
lordship. That they cannot
Now
deny.
you are claiming partition by meets and bound.
Yes, lordship.
Over
But they
what
already
land?
admitted that the already partition was that she was given properties, lordship. They are not denying that I am not entitled. They are saying that D&E already given to you and you are possessing, but I am saying that they have dispossessed me from D&E. The rate of the area became high, lordship. So they dispossessed me. This is a market area, lordship. Earlier I was cultivating and the revenue records are also in the name of the daughter, lordship. Those were not exhibited during the trial of the suit, lordship. For that only order 41 rule 27 petition was filed.
No, how you can, what is your submission in relation to the substantial question of law which has been formulated in this case?
That they
How
cannot-
will you relate that to what you have already submitted till now?
Whether the learned courts below committed wrong in dismissing the suit of the appellant plaintiff on the face of share mentioned under the Mohammedan law for daughters. So as per Mohammedan law, my share is already fixed, lordship.
How much?
And lordship, 1 divided by, out of 7, 1 part, lordship.
How many sons and daughters were there?
3 sons and 1 daughter. For that only that substantial question of law was formulated, and that too on the face of the admission that the plaintiff appellant is one of the legal heirs of the predecessor in interest of the parties to the suit.
No, assuming that this this
They are denying, lordship, that A and B schedule are imaginary. But again, they are admitting that D and E already given to me. D and E my share, lordship. So my entire suit cannot be dismissed, lordship. At least I am entitled for D and E, lordship. Admitted facts need not to be proved, lordship. They are admitting that D and E are my properties, lordship. That was also not given to the plaintiff, lordship. Even if plaintiff failed to prove that there are 40 bighas of land inherited, lordship, by, through her predecessor, lordship. But their admission is that D and E I am possessing and it is my property. That was also not given, lordship.
Where is the plaint? Let us go to the plaintiff.
Page 10, 11, name of the parties, 12, lordship, first paragraph.
These plots of land, these 5 plots of land are situated at different places. Or it is,
Two villages, lordship. And D and E, lordship, from A and B. Your lordship will find schedule A, land measuring 4 katha 16 lesas is situated at Simlabari, covered by Dag number 102-293 of Patta 75. Situated at Kadotika, covered by numbers 39, 40, 41, and the same area will lordship will find in schedule D. Land measuring 1 bigha 4 katha 3 lesa is situated at Markula, covered by so and so, so and so. And out of A schedule is E, lordship. Land measuring 1 bigha is situated at Kadotika, covered by Dag number, same Dag numbers, lordship, as of schedule A.
and D is out of schedule.
B, lordship. B is land measuring 14 bighas, 4 kathas, 11 lesas is situated at Pandova, covered by Dag number 99, 100, 103 of Patta number 104, Khatian number 51, and land measuring 2 bighas.
No, where is the statement that you were dispossessed from
Lordship.
D and E? Seven.
Yes, lordship, that the month of February 2007. Jointly disposes the plaintiff from the land shown in schedule D and E, which were given earlier as part of her share. And since then, the defendants have been refusing to partition the land left by disease Muhammad Ali Haji and disease Sebatan Nessa. Before that, it was stated that after death of mother, lordship. Paragraph 2 and 3, she mentioned her share, lordship. Plaintiff, the deceased Muhammad Ali Haji had owned and possessed the suit land so and so during his lifetime, and he died in 1977. And at the time of death, left behind his heirs such as his wife Sebatan Nessa since disease. So at that relevant time, lordship, the mother's share is 1/8. When there is children, lordship, mother is entitled for 1/8, lordship. And then rest of the 7 part will be divided among the children. And after death of mother, lordship, the entire property will be again divided. Paragraph 4, your lordship, kindly go through of the plaint, lordship.
Okay, where is the law regarding share of daughters in Mohammedan? By whom? Who is the author?
The Hidayatullah. Mullah principle of Mohammedan law, lordship.
Okay, you may read.
Lordship. Lordship, kindly see this part, the illustration part, your lordship will understand.
No, you may read.
Lordship. If one son and
Page number?
page number 54, lordship. Sons and daughters, how it is divided among sons and daughters, lordship. If one son and one daughter, it will be
No,
divided.
that is according to what?
Shares
This
and
mullah is the authority
Yes, lordship.
or
When
according to customary law.
lordship will find, here it is the table of shares, Sunni law. It says daughter will take half of the share of the son. And when son is there, she became residuary, lordship. So the son will take double the share of the daughter, lordship, as per Mohammedan law. The table shows that if there are three children, two son and one daughter.
Okay, so if there are two children,
Sorry, lordship, if
One.
there are one son, one daughter,
so
then it will
property
be
will be divided into three
three parts.
parts.
The
Two
son
will go
will
to
take
son, one
yes.
will go to daughter,
son will take 2/3, daughter will take 1/3.
1/3, okay.
And if two sons, three daughters, then 7 parts.
And there is no dispute regarding this proposition
No,
by the.
lordship, my lord, friend will also admit.
No, madam, this is an uncodified system.
Lordship.
Mohammedan law, this is being followed. Do not object.
So the substantial question of law is that in view of this settled proposition of law,
Both
the,
the committed wrong in dismissing the suit of the,
that the declaration was still necessary.
that is a perverse finding, lordship. That
No, is it your submission that as the fact that you are daughter of late Muhammad Ali has not been denied by the defendant? They have admitted,
they have admitted,
therefore you are entitled to
lordship.
the share
Declaration of
record,
Title is not required, lordship.
not necessary.
That is already admitted by them. And title is always there, lordship. In this decision, lordship, reading. Sayyid Shah Ghulam Ghosh Mahiuddin.
Okay, okay, understood. But their main objection to your prayer, court dismissed. Both the court dismissed your suit on the ground that you did not sought any partition,
Declaration. lordship.
declaration.
Yes, lordship. This is 1971, 1 SCC 597.
597.
Yeah, 597.
Para?
19 para, lordship. Para 20, your lordship will find in Mohammedan law, the doctrine of partial partition is not applicable. Because the heirs are tenants in common and the heirs of the deceased Muslim subject to the definite fraction of every part of his estate. The shares of heirs are under Mohammedan law are definite and known before actual partition. Therefore, on partition of properties belonging to a deceased Muslim, there is division
Who
by
has defined these shares?
Mohammedan law, lordship,
That
as
is,
per Quran, lordship.
okay.
Normally, we do not say any section and all this in Mohammedan law is because it is taken from Quran, lordship.
In Quran, shares are mentioned.
Yes, lordship, everything, entire Mohammedan law was, lordship, described in Quran. The shares, the marriage, the inheritance, and the lordship right of preemption, everything is described in Quran, lordship. The shares of heirs under Mohammedan law are definite and known before actual partition. Therefore, on partition of properties belonging to a deceased Muslim, there is division by metes and bounds in accordance with the specific share of each heir being already determined by the law. So, lordship, I am praying before the court only to give my share, lordship. How much I am entitled, it is already determined. 2007. And for abandoned question, Lordship, I am relying on another judgment, that is 2007 STC, page 215, Lordship. Paragraph 6, Lordship. However, it has been seriously contended that the lease deed of 3/8/1960 was a registered document and that the appellant had been put in possession under that document. It was submitted that the suit was a mere suit for possession. It is pointed out that there was no prayer for a declaration that the lease deed was invalid or void and or not binding. It is submitted that in the absence of such a prayer, the suit was not maintainable. It is submitted that both the courts below erred in holding that the suit was maintainable in the present form. It is correct that such a declaration should have been sought. Normally, in the absence of such a declaration, such a suit would not be maintainable. However, in this case, we find that even though there was no prayer to the effect that the lease deed was not valid and or void and or not binding, the necessary averments are there in the plate. The appellants thus knew that the lease deed was being challenged. They made the challenge in their written statement. Thereafter, issues, namely issue number 4 and 5, had been framed. Evidence was led by the parties on those issues. Arguments were advanced on those issues. Therefore, this question has been hesitated by the parties in all the courts. Thus, even though there was no formal prayer was asked for, no prejudice has been caused to the appellant inasmuch as he has not been prevented from leading evidence on this aspect and has not been precluded from raising contentions in this behalf. In our view, all that was necessary to cure the defect was an amendment by incorporating one prayer. This could have been done at any stage in this view of the matter, and particularly in view of the fact that we are in agreement with the findings that the property is a trust property and that the lease in question was not for consideration or for legal necessity. We see no reason to interpret. So in that case, Lordship, it was held that the prayer is not required, specific prayer is not required. And in this case, Lordship, when there is a specific share is mentioned, Lordship, the right title declaration is not necessary. My title, no one can deny. They can deny at the best that I am not the daughter of late so-and-so. Then only a declaration of title will be required, Lordship.
Okay.
Anything a little bit of confusing, then your Lordship, if your Lordship permit, I can submit my written argument also.
Why the embargo of section 34 of the specific
Specific
relief
relief
is not applicable to your case?
Lordship, that itself says the discussion of the first appellate court '59, Lordship. Section 34 was cited here, Lordship. Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief, provided that no court shall make any such declaration where the plaintiff being able to seek further relief than a mere declaration of title. It says when we ask for, Lordship, right title interest, but we have not prayed for recovery of possession, Lordship. My understanding is that, Lordship, in that case, this section 34 will be applicable. So far, my understanding, Lordship, section 34 is not applicable in this suit, Lordship. After partition of the properties, Lordship, automatically after meets and bounds partition, Lordship, the shares will be determined and the appropriate parties will be given possession of the properties, Lordship. And in all the DW and PW, Lordship, every witness of both the sides admitted that I am the daughter of late Muhammad Ali. I was given property, I was possessing the properties, and D and E are, Lordship, already given to the plaintiff.
Okay, yes.
May please, my lord. My lord, first and foremost, the duty of the plaintiff in a suit would be primarily to discharge its burden to prove its own case and not rely upon the case of the defendant or any weakness in the case of the defendant. In the present case, my lord, which is a case for partition, first condition which was required for the plaintiff was to be a legal heir of late Muhammad Ali Haji.
But that is not disputed.
That is not disputed, I agree. And the second requirement then would be to seek for properties which were left behind on the date of Muhammad Haji Ali for partition. That precisely was the defense taken by the defendants before the trial court, that the properties which have been depicted in the schedules were not the precise properties which were left behind by Muhammad Haji Ali as on the date of his death. Here, my lord, the plaintiffs have failed to discharge the burden. Subsequently, my lord, even during at evidence stage, during cross-examinations, it was also admitted by the PW1, who is the plaintiff, who was the original plaintiff, Basirun Nessa, that I cannot say the total area of Suitland for certain. I claim partition of Suitland. There are 2 dwelling houses of the Suitland occupied by the defendants. So exactly which land is their father? So how does this one come to the conclusion that these are the properties left behind by late Muhammad Ali Haji is something which was never clarified by the plaintiffs in the plaint. No revenue records in the sense were not submitted. It is stated, I have not submitted any relevant revenue records in respect of the Suitland. I do not know what resulted in my evidence, what further has been stated in my evidence in chief. I have not submitted any document in support in respect of the Suitland recorded in the name of my parents. So what was to be established upon establishing first that she is a legal heir of Muhammad Haji Ali? Second, what was to be established is that these all are the properties specifically which were left behind by Muhammad Haji Ali. For that, she ought to have shown documents, since in a case where it would not have been objected to by the defendants that these are the properties left behind, that would have been a different case. But in the present case where it has been specifically, this has been the objection. Evidence ought to have been laid, or it ought to have been shown that these are the specific properties by means of whatever documents were best in the possession of the plaintiff. This burden was never discharged by the plaintiff. So on this count, the plaintiff had miserably failed to prove her case. Secondly, with regard to the plea of partition, it has been specifically stated in the written statement that family partition was carried out as on the date of suit 30 years back, and she was given the share of Schedule D and Schedule E lands. The same fact was also reiterated in the evidence of all the 4 DWs, and even in their cross-examinations, this fact remained unshaken. So in view of this fact that a partition has already taken place, and it was further stated in the evidence that the partition had taken place after the death of the mother. So the contention of the plaintiff before this appellate court that after the death of father, there was a partition, and in which 1/8 property was in the share of the mother, and after the death of the mother, again this 1/8 share of property which fell due in the share of the mother would again be divided amongst the parties, stood nullified because because the plaintiff could not shake the evidence of the defendant that this partition was carried out after the demise of the mother. So therefore, this prayer again does not stand. Hence, in view of all these, my lord, what is stated is the plaintiff has first had to prove the case, and plaintiff has not proved that partition was never meted out, as has been contended, that the properties are the properties left, are the specific properties left behind by Muhammad Haji Ali. In fact, in the evidence, it was also stated that 40 bighas was not the property, and rather some 14 bighas or odd were the property, and proper revenue receipts were also submitted as exhibits A, B, and C by the defendants. Those also remained unshaken during cross-examination, my lord.
But she has claims somewhere that she has been dispossessed from.
My lord, that ought to have been a different suit
Different.
altogether, my lord. If this is a partition suit, my lord, per se. If this was a suit where she had been forcefully evicted, that was a different thing. But here she has also not led evidence to that count as well, even if it is considered. Primarily, this is a partition suit where she is saying, where it is the stand of the plaintiff, my lord, that partition was never conducted in respect of the properties and the property remains Ajmali. When this is the case, and the respondents, as defendants had contended that the partition was effected long back after the death of the mother, it was very well within the domain of the plaintiff as well as in their power to adduce evidence against it, to disprove it during cross-examination, but none of these exercises were carried out during that point of time. Pertinently, only at the appellate stage, they prefer the two petitions under which have been referred to by my learned friend. One is petition 786 at page 69. If my lord kindly takes up the petition for a moment.
Yes.
My lord, and in the cost title, it is mentioned that this is a petition under Order 41, Rule 23A, read with Rule 27 and Section 151. So it is not primarily a petition either praying for remand or a petition praying for adducing of secondary evidence as under Rule 27 of Order 41. My lord will also have a note of the prayer which has been made here. The prayer states, it is therefore prayed that Honorable Court would be pleased to allow the appellant plaintiff to examine additional witnesses to prove the aforesaid documents under the provisions of Order 41, Rule 27. Or be pleased to remand the suit to the trial court, allowing the appellant to examine additional evidence by calling the production. My lord, these are two alternative prayers. First and foremost, if a prayer has to be made under Rule 27 of CPC, Rule 27 of Order 41 of CPC, the ingredients stated therein have to be.
No, an order was passed on this application.
An order was passed
That
stating that it will be
is
considered at the time of hearing,
final stage.
at the final stage.
But in the judgment, there is no mention about.
I'm coming to that one. My lord, the second petition, which is at annexure 7, is also similar in the sense the same petition which was brought forth again by the legal heirs of the plaintiff. The first petition was made by the plaintiff. The second is the same petition with the same prayer.
Second petition is, where is second petition?
Second petition starts from page 72 onwards, my lord. My lord has it.
Sorry, yes.
My lord, in this very petition at para 3, a mention has been made regarding the earlier petition, which was filed on
Who
19.
filed this petition?
The legal heirs of the plaintiff, my lord. The same petition has been filed.
Okay.
The initial was filed by Basiran Nessa, and then her legal heirs filed this petition. And the prayer is at page, next page, the prayer is again the same, either to allow to adduce additional evidence or to remand the case back. In essence, this is the very same petition which was filed earlier. So, my lord, as it has been stated, it has to be considered at the time of argument. Why that is so is because the court has to see at that point of time if this additional evidence which is sought to be adduced is at all required for providing a just decision of the case. In a case, my lord, this is my humble submission, in a case where the plaintiff has primarily failed to discharge her burden to prove her own case, later on at an appellate stage by trying to adduce additional evidence cannot improve upon her case. Had this been, because an order on the basis of the available evidence in my humble submission can be passed against the plaintiff. Had this been a case where there could not be any conclusion which could have been reached on the basis of the evidence available, then it would have been a different scenario. I would humbly request just to go through the provisions of Rule 23, 24, and 27 of Order 41. my lord.
Where is the order which was passed on these petition?
The order is page 62. 62, my lord. This was rightly passed, my lord. It has to be considered at the time of hearing. It cannot be considered before that.
Yes, what you want to show?
The language in each of these provisions. May I read, my lord?
Yes. Order 41 rule.
23 only.
Yes, please read.
My lord. When Rule 23 reads, where the court from whose decree an appeal has been preferred has disposed of the suit upon a preliminary point, and the decree is reversed in appeal, the appellate court may, if it thinks fit by order, remand the case and may further direct what issue or issues shall be tried in the case so remanded, and shall send a copy of his judgment and order to the court from whose decree the appeal is preferred, with directions to readmit the suit under its original number in the register of civil suits and proceed to determine the suit. And the evidence, if any, recorded during the original trial shall, subject to all exceptions, be evidence during the trial after remand. That is only in case of preliminary finding of the court. Rule 23A, which was later included, is where the court from whose decree an appeal is preferred has disposed of the case otherwise done on preliminary point and the decree is reversed in appeal and a retrial is considered necessary, the appellate court shall have the same power as it had under Rule 23. So, my lord, this is the provision on which the plaintiff is relying. So, for this, first and foremost, the judgment against which a decree had been, the decree against which an appeal had been sought for, first appellate court ought to have arrived at a different finding, ought to have completely dislodged that. Only then could it have sent the record, could it have remanded the record back to the trial court. My lord, Rule 24, which is next, would be perhaps pertinent in my humble understanding, where the evidence upon the record is sufficient to enable the appellate court to pronounce the judgment. The appellate court may, after resettling the issues if necessary, finally determine the suit, notwithstanding that the judgment of the court from whose decree the appeal has been proceeded wholly upon some ground other than that on which the appellate court proceeds. Well, this provision gives ample power both upon the first appellate and the second appellate court. Even if a same finding is reached, that the evidence is conclusive and plaintiff was unable to demonstrate her case properly or to prove her case properly, then based on the same evidence, different set of issues may be framed, but the appellate court can very well arrive at the same finding that the suit is dismissed, maybe on a different set of reasoning. but only for that particular purpose a suit cannot be remanded back. Now, my lord, as regards Rule 27, my lord will see that in Rule 27 already certain conditions are mentioned. May I read, my lord?
Yes.
The parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary, in the appellate court. But if A, the court from whose decree the appeal is preferred has refused to admit evidence which ought to have been admitted. But this is not the case here. Evidence rather was not given, there was no refusal. A states, the party seeking to produce additional evidence establishes that notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not, after the exercise of due diligence, be produced by him at the time when the decree appealed against was passed. This is also not the case, my lord. Nothing has been pleaded of that sort in those petitions. And B, the appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment or for any other substantial cause. Whereas, my lord, in this case, it stands clear and unrebutted that that the properties which are claimed by the plaintiff could not be proved to be the specific properties of Muhammad Haji Ali. Secondly, that a partition which was taken as a defense by the defendants happened after the death of the mother, that is Sariton Nessa, was never dislodged during cross-examination or by adducing other evidence. So it clearly there are materials on record to show that the plaintiff could not prove her case, and hence the suit ought to be dismissed against her. I would agree that maybe the grounds which have been stated in the judgment can very well be molded and changed under Rule 24 of Order 24 of Order 41, as I have read earlier.
What is the submission regarding the substantial question of law?
The substantial question of law, my lord. My lord, the first substantial question of law which has been whether the learned courts below committed wrong in dismissing the suit of the appellant plaintiff on the face of share mentioned in the Mohammedan law for daughters, that too on the face of the admission that the plaintiff appellant is one of the legal heirs of the. This admission, my lord, would not tantamount to partition in this case, because this is only one of the conditions which is required by the plaintiff to prove that she is a legal heir. Secondly, she also has to show that the properties which has been in respect of which claims have been made are the properties which are to be partitioned, and more so in case when a defense has been adopted by the defendants, that a partition has already been maybe it has already taken effect, and D and E, which rightly has been admitted, are in the share of the plaintiff. If that is the case, my lord, already partition has taken place.
So their plea that you were dispossessed, she was dispossessed, for
My
that
lord, that ought to have been a
other
defense.
relief,
My lord, I'm sorry.
some other relief.
Some other relief, some other suit, my lord, but that was never agitated here. No evidence was led in that regard. If partition has once happened of the entire properties, if that was the defense taken by the defendants, what fell upon the plaintiffs was to dislodge that defense either by way of providing.
Otherwise, you have admitted that property mentioned in Schedule D and E fell in her share.
My lord, that is admitted in the.
That is in the
admitted in the
written
written
statement.
statement. That is record. So my respectful submission before your lordship, plaintiff's suit, entire suit cannot be dismissed. So first appellate court and the trial court both are wrong in dismissing the suit of the plaintiff. D and E, she is entitled. And the case of the plaintiff is that after death of father, amicable settlement was done, and thereafter Schedule D and E was given to her. And later on, her mother died, thereafter no partition. And this fact was admitted by DW2 in his cross, lordship. I am reading that part, lordship.
No,
DW
that they are admitting.
Yes, lordship. It is admitted after
D and
death.
E we are admitting.
No,
Yes.
lordship, that after death of my grandmother, there was no partition. So plaintiff's case is that before mother's death, she was given share, D and E. After mother's share, she is entitled for more land, lordship. Mother's share will be distributed among the legal heirs, lordship. That was also admitted by DW2.
DW two says after death of my grandmother, no partition took place.
Page number?
DW two cross part, your lordship will find. DW two is, your lordship may write his name Jahangir Alam. Their case is that, lordship, if you are dispossessed, you file a suit for recovery of possession. But that is not, that means they are admitting that I was dispossessed from my D and E schedule land. And plaintiff's specific case in para 4 that after death of my father, I was given D and E schedule, and after death of my mother, there was no partition. And that case was admitted by DW2. And DW3 also admitted, DW3 is Rustam Ali, lordship. He is an independent witness. He admitted in a cross second page that as I know from lordship, about 6-7 years after Sabatan Nessa died. So plaintiff's case is that after death of father, after 6-7 years, mother also died. After the death of Sabatan Nessa, the plaintiff was given land from both.
How much share you will get from your mother's?
Again, lordship, the mother's share will be divided into 7 parts. I will be entitled for 1 part.
Same calculation will follow.
Same calculation, lordship.
If the daughter gets X, the son gets.
Okay, what judgment you were referring to? Okay.
The DW3 admitted that as I know from some village name, 2-3 bigha of land was given to plaintiff. Their own witness is admitting the case of the plaintiff. DW2 is admitting that after my grandmother death, no partition took place. So lordship already admitted that D and E I am entitled. Plaintiff is the legal heir of late Muhammad Ali and Shabatan Nessa. So she is entitled for the share from both Muhammad Ali and Shabatan Nessa. Only lordship, that area of land, if it is required to be proved at all, lordship, then the best option will be, lordship, to remand the case to the first appellate court. As lordship, the first appellate court also did not consider my order 41 rule 27 petition. My learned friend has just read the petition by the legal heir. Legal heir prayer was not there for remanding the case. It is the language itself in the prayer portion your lordship will find. It is therefore prayed that Honorable Court would be pleased enough to allow the newly impleaded substituted appellants to examine the additional evidences to prove the aforesaid documents on remand. So their main prayer was to adduce additional evidence, and this petition was, there was no finding by the learned first appellate court in the judgment, lordship. So as soon as my petition will be considered, the plaintiff is will be able to prove the documents, adducing the revenue record showing that the late Muhammad Ali was owner of that much land, lordship. So my
Yes.
entire suit dismissed that the first substantial question of law is admitted, lordship. It is proved, lordship. The first appellate court committed perversity by denying the share of the lordship.
Yes, Mr. Chaudhary, how much time will you take more? 15 minutes. We'll continue at 2. You will have to submit written arguments.
Time, lordship, within.
I'll mention it, tell you at 2 after hearing his.
I'll just address short points on law and then I'll address the contention with regard to partition of the mother's share. My lord has this citation which is 2021 11 STC 277.
Yes, Para.
Para 26.3 onwards, my lord. Internal page number would be 42, the third last page.
26 point.
3, my lord. A
Hmm.
comprehension of the scheme of the provisions for remand. My lord has it.
Yes.
Remand contained in rules 23 and 23A of order 41 is not complete without reference to the provision contained in rule 24 of order 41 that enables the appellate court to dispose of a case finally without a remand if the evidence on record is sufficient, notwithstanding that the appellate court proceeds on a ground entirely different from that on which the trial court had proceeded. Meaning, my lord, the judgment may be changed. So far as the reasoning may be changed, but the result may remain same without remand if there is conclusive evidence on record.
No, result may also change.
May also change, my lord.
If there
May or may not.
whether condition to be considered is whether sufficient evidence is there on record to arrive at a decision on.
Arrive as a conclusive decision, my lord. It may also be the rejection of the suit, which continues. A conjoint reading of rules 23, 23A and 24 of order 41 brings forth the scope as also contours of the powers of remand that when the available evidence is sufficient to dispose of the matter, the proper course of an appellate court is to follow the mandate of rule 24 of order 41 CPC and to determine the suit finally. It is only in such cases where the decree in challenge is reversed in appeal and retrial is considered necessary that the appellate court shall adopt the course of remanding the case. It remains tried that order of remand is not to be passed in a routine manner because an unwarranted order of remand merely elongates the life of the litigation without serving the cause of justice. An order of remand only on the ground that the points touching the appreciation of evidence were not dealt with by the trial court may not be considered proper in a given case because the first appellate court itself is possessed of jurisdiction to enter into facts and appreciate the evidence. There could, of course, be several eventualities which may justify an order of remand or where remand would be rather necessary depending on the facts and given set of circumstances of a case. 26.5, 4.1, a case has been referred to. I will not bother your lordship with that. 26.5, my lord. It gets perforce reiterated that the occasion for remand would arise only when the factual findings of trial court are reversed and a retrial is considered necessary by the appellate court. The present case had clearly been the one where the parties had adduced all their evidence whether they wished to, and it had not been the case of the appellant plaintiffs that they were denied any opportunity to produce any particular evidence or if the trial was vitiated because of any alike reason. As noticed, there has been several suspicious circumstances surrounding the will in question, some of which were noticed by the trial court but were brushed aside by it on untenable reasons. The High Court has meticulously examined the same evidence and same circumstances have come to different conclusion that appears to be sound and plausible and does not appear suffering from any infirmity. There was no reason or occasion for the High Court to consider remanding the case. My lord, in this case, on the basis of materials available on record, a different finding, different reasoning was reached with the same finding with regard to the will. Whereas even in this case, it has been said that remand is a power to be exercised sparingly after seeing if at all there is a lacuna of evidence and if there is any contention from the other side that they were not allowed to adduce any evidence or that
their contention is that though a prayer at the appellate stage was made for reducing additional evidence, that was not considered by the appellate court.
My lord, that is with regard to Rule 27. I have provided a citation for that. I'll rely on that. My lord, the next citation 2023 SCC online SC 196.
Para?
My lord, para 28 onwards. It relies on the same discussion as was in the earlier case.
It is also with regard to remand.
With regard to remand, my lord. My lord, if my lord pleases, I may not go through the paragraphs. Paragraphs 28 to 33 would otherwise be relevant. Here also remand was sought for. Next is, my lord, the judgment which my learned friend has also cited. Union of India versus Ibrahim Uddin and another. 2012 8 SCC 148. Here, my lord, that question with regard to a document which you and how it is to be accepted by the court has been provided from para 36 onward.
What question?
My lord, question with regard to production of additional evidence at the appellate stage, order 41 rule 27, para 36 onwards, my lord.
Yes.
The general principle is that the appellate court should not travel outside the record of the lower court and cannot take any evidence in appeal. However, as an exception, order 41 rule 27 CPC enables the appellate court to take additional evidence in exceptional circumstances. The appellate court may permit additional evidence only and only if the conditions laid down in this rule are found to exist. The parties are not entitled as of right to the admission of such evidence. Thus, the provision does not apply when, on the basis of the evidence on record, the appellate court can pronounce a satisfactory judgment. The matter is entirely within the jurisdiction of the court and is to be used sparingly. Such a discretion is only a judicial discretion circumscribed by the limitations specified in the rule itself. The next paragraph. The appellate court should not ordinarily allow new evidence to be adduced in order to enable a party to raise a new point in appeal. Similarly, where a party on whom the onus of proving a certain point lies fails to discharge the onus, he is not entitled to a fresh opportunity to produce evidence, as the court can, in such a case, pronounce the judgment against him and does not require any additional evidence to enable it to pronounce the judgment. This is, my lord, precisely the reason why it was not allowed at the appellate stage. At the appellate stage, under the provisions of order 41 rule 27, the adducing of evidence is only permitted subject to certain limitations which are present, and that too at the discretion of the court, where the plaintiff had to show that during trial it was stopped owing to certain reasons to produce the evidence which they want to produce in the appeal. Next paragraph, my lord. Under order 41 rule 27 CPC, the appellate court has the power to allow a document to be produced and a witness to be examined. But the requirement of the said court must be limited to those cases where it found it necessary to obtain such evidence for enabling it to pronounce judgment. The provision does not entitle the appellate court to let in fresh evidence at the appellate stage, where even without such evidence it can pronounce the judgment in a case. It does not entitle the appellate court to let in fresh evidence only for the purpose of pronouncing judgment in a particular way. In other words, it is only for removing a lacuna in the evidence that the appellate court is empowered to admit additional evidence. It is not the business of the appellate court to supplement the evidence adduced by one party or the other in the lower court. Hence, in the absence of satisfactory reasons for non-production of evidence in trial court, additional evidence should not be admitted in appeal, as a party guilty of remissness in the lower court is not entitled to the indulgence of being allowed to give further evidence under this rule. So a party who had ample opportunity to produce certain evidence in the lower court but failed to do so, or elected not to do so, cannot have it admitted in appeal. Well, next para is the last I'm relying on. The inadvertence of the party or his inability to understand legal issues. It has been specifically stated, my lord. This is also one of the grounds taken by the plaintiff in their petition for additional evidence.
Which para?
Para 40, my lord.
Yes. Yes.
The inadvertence of the party or his inability to understand legal issues involved, or the wrong advice of a pleader, or the negligence of a pleader, or that the party did not realize the importance of a document, does not constitute a substantial cause within the meaning of this rule. The mere fact that certain evidence is important is not in itself a sufficient ground for admitting the evidence in appeal. My lord, it has been clearly established by a plethora of judgments even prior to this, that what is to be seen by the court is whether it is required to arrive at a decision. Decision may be for or against the plaintiff, but it must be required to arrive at a decision. But in this case, as I have already stated, the plaintiff could not prove as to whether those were the specific properties of Ali Haji. I'm sorry. Yes, Ali Haji. Now, my lord, the contention which has been brought about by my learned friend, that even if they are not entitled to a partition of the properties of Ali Haji, if I have understood correctly, after the death of the mother, there arises another cause of action for partition of their properties. If that
No,
is,
no. Their submission is that admittedly land in schedule
D&E.
D and E fell in her share according to the defendants also.
Yes, ma'am.
But after death of the mother, he would get some additional share of her mother also. That was not given.
In that regard, my lord, I would.
That is, Lordship, para 4, it is clearly stated in my plaint that as per the provision of Mohammedan law of inheritance, the plaintiff was entitled to land measuring 5 bighas, 7 lesser just after the death of Muhammad Ali Haji, page 12, Lordship. But the prior to death of her mother, Shebatan Nessa, but she was given land measuring 1 bigha 4 katha 3 lesser at Martula as shown in Schedule D and 1 bigha at Kadotika as shown in Schedule D. And as her mother was alive then, she did not claim the remaining share at the time. So it is the case of the plaintiff that she was given some share after father's death, and subsequently they disposes from that share also. And now as mother died, so the partition may be done afresh, Lordship. That is the case of the plaintiff.
What is your submission, Mr. Chaudhary, regarding the substantial question of law that the trial court did not took into consideration the Mohammedan law of succession of property by daughters?
My lord, first and foremost,
Whether this substantial question of law is involved in this case or not?
in my humble submission, no, my lord, because the understanding that Mohammedan law, the provision of Mohammedan law was not taken into consideration by the trial court would not be correct, since the question of law would only follow once it has been established. Question of law only states as to how much share she is entitled to as a tenant in common in the property left behind her by her parent. For that, first and foremost, she would have to show that there is a property in respect of which she is entitled to partition. A complete reading of the plaint in my humble submission, my lord, would show, as my learned friend has read, para 4, that as per the provision of Mohammedan law of inheritance, the plaintiff was entitled to land measuring 5 bigha 7 lechas just after the death of her father, Muhammad Ali Haji, but prior to the death of her mother, Sebatun Nessa, but she was given 1 bigha 4 katha 3 lecha at Markula as shown in Schedule D and 1 bigha at Kadotika as shown in Schedule D. And as her mother was alive, then she did not claim the remaining share at that time. Mala, this share, which she has alleged in imputed in para 4 of the plaint, 5 bigha 7 lecha, that is stated to be the shares which she is entitled to after the death of her father. Undoubtedly, this has been found by the defendants at para 10 of the written statement. She states that this 5 bigha 7 lecha is a share after the death of her father, but prior to the death of her mother. And the remaining share of her mother, therefore, she did not claim, if that is the submission. My lord, a holistic reading of the plaint would show that she is claiming that a partition of the property was not done after the death of the father, owing to which she did not get her share. And therefore, after the death of her mother, now she is claiming the entire partition of the property. If that is the case, my lord, now to come and improve the case and say that fine, D and E are there since it has been admitted by you. But now since there was a death of my mother, I am entitled to some additional share. That was never specifically pleaded or shown what share she is entitled to anywhere in the claim. It has specific categorically been, this paragraph 4 has been categorically been denied in the written statement at page 20.
Okay.
At page 20, para 10, the written statement, it has been denied. And more so, my lord, the calculation which was presented by the plaintiff of this 5 biga 7 lecha after the death of father, this is in with regard to the fact that the plaintiff has also imputed in a plaint that there was a the late Muhammad Ali Haji left behind 40 and odd bigas of land, which was also disputed by the defendants. This fact has not been proved anywhere through evidence. If it has to be corresponding, my lord, in my humble submission. 40 bigas, if this much is the land. Now, if we say the land is less, then very well the share was given in accordance to what was due to her. She could never prove that this quantum of share she is entitled to. That was never proved by the plaintiff in her case.
In both of you, if possible, submit written bullet points of your main argument with reference to the substantial point of law.
Very well.
When will you be able to submit? 19th.
Last
I'll deliver after vacation.
Thank you.
Heard Miss R. Chaudhary, learned counsel for the appellants. Also heard Mr. M. Chaudhary, learned counsel for the respondent. The hearing is concluded. However, learned counsel for both sides are requested to submit their written gist of their respective arguments on 19th December 2025.
Or it will be listed again.
We'll list it again.
Lordship.
We'll list it again. 19 December 2025. List this matter again on 19 December 2025 as partnered matter.
Submit the trial court rejected my suit. One more ground they have taken that court fee, deficit court fee. Lordship. On that ground also I have some decisions. Though I have not argued as because the substantial question of law
You
was-
may submit your respective
Lordship.
points and decision. If you refer, you have already referred the decisions. If any additional decision is referred,
Lordship.
please mention the paragraphs on which you are relying.
Keep reply.
Obliged.
Please, you know.
Where is the other side?
My lord, my learned senior friend was just here. I've sent my junior to inform.
Who is he? What is his name?
R. Devi.
R. Devi.
Yes, my lord.
She has to be there.
My lord.
She has, what is the facts?
My lord, in this matter, I'm challenging the judgment passed by the Railway Claims Tribunal. And my lord, the railways have imposed terminal charges, my lord, which is illegal. Illegally imposed terminal charges, my lord. Our Honorable High Court have held that imposition of terminal charges apart from the 50 station will be illegal. And the tribunal has declared it as per incurium, my lord. our honorable High Court judgment, the tribunal has declared it as per incurium and is constantly dismissing all my
For
pending cases.
incurrum, it has referred to some Supreme Court decision.
No, my lord, the learned tribunal has relied upon another our honorable High Court judgment in respect to this, but the facts and both the proposition laid down in both the judgments are different. And my lord, the judgment which I am relying upon after this tribunal judgment, it was appealed before the Supreme Court, my lord. The judgment which was declared as per incurium, it was challenged before the Supreme.
It was not declared as per incurrum.
It was
Which the
by
trial,
the tribunal, by the tribunal.
it was upheld by the apex court.
Yes, my lord, it was upheld by the apex court, but before it was upheld by the apex court, my lord, the tribunal has passed a judgment that it is a per incurium one. And Supreme Court has, however, upheld this judgment. The entire case is based, covered question of law, my lord, everything is there.
Okay, but where is the other side?
My lord, I'll inform if this can be passed over for the timing, last item, if it can be taken up as.
This is the last item.
There's one more.
One more. Okay. Call the other item. You inform.
I'll inform. Much okay. Hello, this matter. What has happened is the petitioner has previously claimed before the tribunal on account of illegal collection of terminal charges by the railway authorities. On account that the terminal charges has been imposed on the stations apart from the 15 notified stations, my lord, as per Railway Board circular. If your lordship may look upon the Railway Board circular dated 5/6/2007, and it's as annexure to page number 89, my lord.
Page number?
89. Lordship is there, my lord.
Yes.
My lord, this 5/6/2007. My lord, before going into the circular, if your lordship may just permit me to give a short background in regard to terminal charges, my lord.
Yes.
Terminal charges, my lord, it has been brought by the railway in 2007 for the first time, my lord. Before 2007, there was no concept of terminal charges, and there was no rule in regard to terminal charges. my lord.
What terminal charges means?
My lord, terminal charges means these are the charges which are imposed by the railway based on certain services that they will be providing in the stations. For example, my lord, this 50 station which has been mentioned to be notified as terminal station, my lord. Herein, it has been mentioned what are the development it will be done and what are the services it will be providing. And these stations are being declared as terminal station. And any station which are declared as terminal station will be notified as terminal station has to give this facility, which would amount to terminal charges. My lord. My lord, this 5/6/2007 circular, if your lordship is there. Herein it is stated in pursuance to, if your lordship is there,
Page number 89.
89, my lord.
Yes.
In pursuance to Honorable MRS announcement during Budget 2007-8 regarding development of freight terminals, a meeting was held on 16th April 2007 with CTPMs of Zonal Railway, in which 50 goods shed were identified for upgradation, emphasis applied. The norms of the numbers of goods shed lines required handling and traffic of the identified good. So railway will be providing handling further. The point 3, my lord. The desirable facilities in each of these goods sheds are listed below, my lord. Rail level, high level platform with without covered shade, depending upon the commodity handle. In case there is only one line, it shall have only one RL platforms. in such that one side direct delivery and on the other side HLPF is possible with sufficient circulation area. B, a puka circulation handling area. C, all weather approach road. D, lighting, including lighting. All these are facilities, my lord, which have been mentioned. And the railway declared, if the lordship may look upon page number 92, my lord. These 50 good shade are being notified as terminal station, my lord. At page number 92, annexure 1, the name of the 52 stations have been mentioned.
Page number 92.
Yes, my lord.
Okay. Yes,
Yes, my lord. My lord, this 50 station was notified.
50,
50, in
but
page
in page 90, there are
92, my lord.
92, there are lesser numbers of,
My lord, this Jalgaon, New Mulund, Solapur, Ahmednagar,
okay,
these are area wise. In the left side, the
Okay,
area has been mentioned. In
okay.
the right side, the name of the stations have been mentioned. Now, my lord, based on this circular, our Honorable High Court have passed this judgment. It's a 2024 judgment. My lord. Two judgments. My lord is there at para 10.
of which,
Both are same, my lord, same judgment. MFA 42 and 105. Para 10, my lord.
there are 10. Yes,
It is stated, regarding the second question, there is no quarrel with the proposition that there are 50 specific station having all the infrastructures for loading and unloading of goods. And if any of those 50 stations are used, then only railway can charge terminal charges. For other station, railway cannot levy terminal charges. The railway has to refund the terminal charge, my lord. In this case,
on what basis this observation was made?
based on relying upon the circular, my lord, 56/2007, the circular which I just mentioned, my lord. These are the 50 notified station for the terminal charges, my lord. Based on the circular, the Honorable Single Bench has held that only railway can impose terminal charges on only in this given 50 stations, my lord.
But the notification which you have shown,
Yes, my lord.
it only speaks about upgradation of 50 stations.
My lord.
It does not say that terminal charges can be imposed only on these stations.
Yes, my lord.
It only relates to upgradation of those stations. It does not say that those terminals which are not upgraded,
Yes.
railway will not levy any terminal charges.
Yes, my lord. My lord, in this respect, this circular, before this circular, my lord, there's this another railway circular which is stating that terminal charges will be applicable.
You are relying on the judgment of the coordinate bench.
Yes, my lord. I am relying on that judgment which was upheld by the Supreme Court, my lord.
Where is that?
And my lord, based on the judgment,
Apex Court has not passed any reasoned order.
yes, my
It has only dismissed the
this was SLP preferred by the railways. my lord. It was, and apart from that, my lord, this 50 station, my lord, these are the 50 station which have these facilities, my lord. These are notified as the terminal station, my lord. There is no other stations which are been notified as terminal. station.
Terminal charges are levied as per what provision?
My lord, exactly, my lord. My second point of argument is that, my lord, the railway has unilaterally passed a rule that terminal charges will be applicable. Now, my lord,
Where is that rule?
my lord, the notification I have annexed as annexure 3, page number 97. Lord, it is there, my lord.
Yes.
Levy of development surcharge and terminal charge, my lord. It was the first time the terminal charge has came into the concept, my lord. Sanction of central government is hereby accorded to levy of development surcharge on goods tariff, which will be 2%. Sanction of central government is also accorded to levy of terminal charge of ₹10 per ton per terminal. This terminal will be levied for bulk and loose traffic on railway owned terminals and siding and not on terminals owned by the customer. The same will be collected at the time of issue of RR itself. These charges will be leviable on loading and unloading of terminals independently and separately on the basis of the chargeable weight at the time of issue of RR. Figures of any subsequent payment shall not be reckoned for levy of the terminal charges, my lord. And the illustration of the calculation of the terminal charges has been given, my lord. This instruction will come into force with effect from 1st July 2007, my lord. And my lord, this five.
So by on strength of this notification
Yes,
circular,
yes,
terminal charges were imposed.
yes, my lord.
But it does not say that terminal charges will be applicable only for those 50 stations
My
which have been upgraded. This notification is not put to challenge.
My,
Whether this circular has been put to challenge.
my lord, interpretation of this 5/6/2007 circular has been made in a way, my lord, that these are the 50 notified stations, my lord. And because, my lord, if the railways are imposing certain charge upon me, at least they are supposed to provide me certain facilities. And these are the stations who are upgraded as a terminal station, my lord. These are the railway owned terminal, these are the railway stations, my lord. Now these have been upgraded to terminal, my lord, terminal station. This 5/6/2007 circular is stating it has been upgraded to terminal, notified terminal station, my lord.
Where is that?
Development of freight terminals, my lord. In respect to this, in pursuance, 50 good shades were identified for upgradation, my lord, for terminal stations, my lord.
These are only for upgradation, lordship. These are not notified as stations for as a terminal station to levy the terminal charge, lordship. It is the proposal was a call for lordship for development or everything, all these, lordship.
Okay, no, I'll come to you.
Lordship.
I'll come to you. Wait.
Lordship, lordship.
Mr. Rathi,
Yes, ma'am.
that is a pertinent question.
Yes.
This notification appears to be notification for only upgradation of some of the identified station,
As for terminal stations.
not as. These are already development of freight terminal.
Yes, my lord. My lord, if the railways are imposing certain charge, stating that it to be a terminal charge, then, my lord, those services has to be provided, my lord. Only these 50 stations consist of those services, and in accordance to those services, these stations.
So other
will be
stations are
upgraded.
not
No, my lord, they do
Freight
not have the
terminals.
facilities, and in fact, the railway have not even denied in the written statement or anywhere. In fact, the railways are stating that we are not even obligated to give you the services in this 50 station also. It's my discretion whether I will give you or not. That's my discretion, but I will impose terminal charge upon you. That's the stand of the railway, my lord. And in fact, the learned RCT have also held that it is the discretion of the railway to give certain charge or not. It is not binding upon.
In your case, from where the journey was,
My lord, the journey
where the goods were uploaded,
Jogi Ghopa, my lord.
Jogi Gopa, and
The
till
destination was Hardoi.
in between there is no notified.
These two stations are not notified as terminal stations, my lord. And if your lordship may allow me to, my lord, the chronology of dates, my lord, your lordship may find that this terminal charge will only be applicable to the 50 station, my lord. My lord, this 5 June 2007 circular, my lord,
Okay.
my lords may look upon the previous circular, the reading both the circulars together, my lord. The one is at page number 97, my lord, which I have read. It is stating that the instruction will come into effect from 1st July 2007. That means the terminal charges will be applicable from 1st July of 2007. And my lord, this 5/6/2000 circular, which is stating about the 50 station, it is stated that all the zonal railway should move proposal for the development of goods shed and submit them to the board or inclusion of supplementary work programs by 30 June 2007, my lord.
Where are you reading?
My lord, page number 89,
Yes.
the circular point 8, my lord, the next page, point 8. It is stated the supplementary work programs, June 2007, my lord.
Okay.
So the development will be done by June 2007, 38 June 2007. The terminal charge will be start applicable from 1st July 2007. And only in this 50 station, my lord, because these station consist of the facilities and can be developed as freight terminals, my lord. Not all the stations all over the India, my lord. And based on this 5/6/2000 circular notification, my lord, the interpretation has been done by our Honorable High Court.
Okay.
That it
Nah.
can be only levied in the 50 station, my lord.
In the High Court's judgment, whether these reasonings were given?
My lord, it has been simply mentioned that these are notified as freight terminal 50 stations and
Well, now, where is the impugn order? Impugn
my
judgment.
lord, there's another point of I just have 2 points, my lord. The first is this 50 specified station and our Honorable High Court judgment, which was the SLP was dismissed by the Supreme Court, which I placed. My lord, second submission, my lord, the terminal charge is a rule, my lord. Whenever, my lord, this rule has been passed by the subordinate legislature without there being without this rule being passed by the parliament, my lord. My lord, as per section 199 of the Railways Act, my lord, whenever a rule has to be passed, whenever a rule has been imposed, the rule has to be passed by both houses of the parliament. If your lordship may look upon section 199.
199 Railways Act. Railway Act. You read it slowly.
Yes, my lord. Rules to be laid down, rules to be laid before parliament. Every rule made under this act shall be laid as soon as may be after it is made before each house of the parliament while it is in session for a total period of 30 days, which may be comprised in one session or in 2 or more successive sections, And if before the expiry of the session, immediately following the session or successive session aforesaid, both house agrees in making any modification in the rule, or both house agree that the rule should not be made, the rule shall thereafter have effect only in such modified form or be of no effect as the case may be. So however, that any such modification or annulment shall be without prejudice to the validity of any provision previously done under this rule.
So the freight has been, terminal charges is imposed by way of a circular, rate circular,
My-
not by rules.
My lord, the rule has been mentioned. In the circular, it has been mentioned, the terminal charge is a rule. I'll just. If your lordship will look on page 99, my lord.
Nine-
Circular 18th September 2007.
Yes.
Herein it is stated, in suppression of the rules regarding levy of terminal charges notified by letters event number 29/5/2007 dated 19/7/2007, sanction of the central government is accorded to levy of terminal charges at the rate mentioned below, my lord. The rates are mentioned, my lord. It, in emphasis applied on the first line, my lord, in separations of the rules regarding levy of terminal charge, my lord. These rules has been brought, my lord.
No, but what rules? No rule has been specified. Rules must have a nomenclature.
Yes, my lord.
This is by way of circular. This is also a circular.
Yes, my
The
lord.
earlier one was also a circular.
Yes, ma'am.
Though the word rules have been mentioned,
Yes.
the terminal charges were levied on the basis of a circular, not as per rules.
Yes, ma'am. My lord, from this bare reading the term, my lord, what I can derive is the terminal charges of the rule brought by the legislative, brought by the subordinate legislature. And it has to be, rules has to be passed under 199, my lord. In fact, my lord, our honorable High Court judgment in a similar aspect, my lord,
What is this?
my lord, it is in respect to section 199, my lord. At para 21, my lord. If I may read, my lord.
Yes.
In the backdrop of the above, the question therefore arises as to whether the impugned circular, which are in the nature of guidelines issued by the Railway Board, circular, my lord, only, are in the nature of guidelines issued by the Railway Board, can override the Rule 126 of the General Rule as amended. Rule 126 1B of the General Rules makes it clear that when a consignment of the packages chargeable at different rates, a group of packages chargeable at a particular rate is improperly described and thereby a lower rate is obtained. The charge at 4 times the applicable freight rate referred to in the subclause A of the Rule 126(1) shall apply only to the group of package in the consignment improperly described and not to the entire consignment. If this court takes note of clause 2.6 of the impugned circular, it stipulates that if any misdeclaration is detected in container haulage charge on the entire rate shall be levied at 4 times of the highest container class rate. Therefore, the rule 126(1)(b) of the general rule and clause 2.6 of the impugned circular are contradictory to each other insofar as consignment where a part of the consignment is improperly described and the others not. This code finds it relevant at this stage, emphasis applied from here onwards, my lord. This code finds it relevant at this stage to take note of the judgment of the Constitution Bench of the Supreme Court in the case of Sant Ram Sharma vs. State of Rajasthan, wherein it has been held that the government cannot amend or supersede statutory rules by administrative instruction. But if the rules are silent on any particular point, the government can fill up the gap and supplementary rules and issue instruction not inconsistent with the rule already framed. Therefore, it is the opinion of this court that clause 2.6 of the impugned circular cannot apply in the respect to a consignment of the packages chargeable at the different rates wherein the group of package chargeable at a particular rate is improperly described and the other group has properly described. The said clause 2.6 of the impugned circular shall only apply to the cases where the entire consignment of the package has been improperly described or if the consignment has been loaded in the container improperly described in the case of false declaration, my lord.
No, this is a, facts are different. Here the earlier, here the statutory rules were sought to be amended or altered by administrative instruction. The court held that that cannot be done. But in the instant case, the terminal charges were imposed by way of an administrative circular at the first instance itself.
If the lordship will look upon para 19 of this judgment.
Yes.
Section 30 of the Railways Act confers upon the central government to fix rates, my lord.
Yes.
They cannot impose additional charge, my lord. It is an additional charge brought in 2007. The Railway Act has been passed in 1989. Section 30 stipulates that the central government may, from time to time, by general or specific order, fix for the carriage of passenger and goods rates for the whole or any part of the railway, and different rates may be fixed or different classes of the goods and specify in such order the conditions subject to which such rate shall apply. Subsection 2 of Section 30 of the Act 1989 further empowers the central government to fix the rates of any other charges incidental to or connected with such carriage, including damage wharfage for the whole or in part of the railway, and specify in order the condition subject to which such rate shall apply. Section 198, my lord. Section 198 of the Act of 1989 is the rule-making power of the central government for carrying out purposes. Further, Section 199 of the Act stipulates that the rules has to be laid before the Parliament in the manner stated therein, and the modification or annulment of the rules upon being laid has to be agreed by both House of the Parliament. The goods tariff number 41 containing general rules of acceptance, carriage, and delivery of the goods were made in exercise of power of Section 198 and 199, 198 of the Act of 1989, for which the said general rules are statutory in nature, my lord. However, in my case, my lord, 198 and 199 compliance has not been there, my lord.
No, in your case, the terminal charges were levied in exercise of powers under Section 30 of the Railways Act by the central government by issuing administrative directions. No, can you show any rule by which there is no rule has been made? And Section 30 plain reading shows that for fixing rates, rules need not to be made. It may be by general or specific orders of the government.
My lord, in regard to fixing of the rate, my lord, herein a new charge has been brought, a new rule has been imposed, my lord, upon me by the railway. Before 2007, there was no concept of terminal charge. A new rule has been brought in 2007, which has not been passed by the Parliament. Section 30 only is limited to fixing of the rates, my lord. The rates can vary from due to inflation or with the time or depending upon the traffic of the railways, my lord. there is a heavy traffic, then the rates can be hiked accordingly, my lord. But only in regard to fixing of the rate, not in regard to imposing a new rate, imposing a new charge or a new rule, my lord. Section 30 does not empower.
So no rule has been made
No rule, no, my lord. And
for imposing terminal
I've
charge.
annexed the RTI reply. I've preferred a RTI application before the Lok Sabha, my lord.
That is there any rule?
Yes, whether any rule has been passed in regard to this, my lord, I have annexed it at page number 103, my lord.
Yes.
My lord, in the next page, the query along with the answer has been mentioned.
What was the query?
Our query was, please provide information regarding page number 104, my lord. Please provide information regarding modification rules of the circular number so and so dated 29/5/2007 and circular dated 18/9/2007 respecting section 199 of the Railway Act 1989 or not. The second question was, please inform me that the approval of each house of the parliament under section 199 of the Railway Act 1989 is mandatory or any modification on subsequent direction issued. The answer was the records available in the branch have been gone through. No motion for
What
modification.
this circular which you have mentioned
Yes, ma'am.
relates to?
Whether any rule has been passed in.
No, this circular number TCR 10, what is this circular?
My lord, this levy of terminal charges, my lord.
Okay.
Which I've read, my lord. No motion for modification annulment of the said rule was passed by the Lok Sabha, my lord. The answer given.
Because that rule was not modified.
My lord, passed, in fact, it was neither passed. The reports available in the branch have been gone through. No motion for modification.
For modification or annulment only. Your question was
Whether it has been passed or not.
whether it has been modified. Any information regarding modification. So they have answered your query. No motion for modification or annulment.
My lord.
Nothing more, no more information was provided. So this cannot be a basis. This will not support you.
My lord, if in this respect, my learned senior friend for the railway can give any explanation as to if this rules has been
Yes.
passed by the parliament.
Yes, after you complete your
Yes, my
submission.
lord. Second, my lord, third point, we have also preferred one RTI in regard to this notification, seeking whether these facilities mentioned in this 50 station are mandatory or not, because the learned tribunal has held that it is not mandatory. So we have preferred the RTI to the railway only, and the railways are stating that, yes, my lord. At page number 102, my lord, the RTI is there, my lord.
Yes. What it says?
My lord, the question one. Please inform me as to whether Executive Director Planning Railway Board Circular bearing number 5/6/2007, my lord, the 50 good shed circular which I mentioned, is still effective and there is any amendment, modification and change in the said Railway Board Circular bearing 5/6/2007. So answer was no change. Question two, please inform me as to whether Executive Director Railway Board Circular dated 5/6/2007 in the matter of providing facility in 50 good shed is still effective as on date. The answer is yes.
Yes, it is effective.
My lord, the facilities. I'm speaking about the facilities, whether the facilities are still effective or not.
So answer is yes, it is there.
Providing facilities, my lord, whether facilities are there or not, but I'm asking whether providing facilities are effective or not.
So answer is yes.
Yes, my lord. So they have to provide me
They
this.
have to provide.
Yes, my lord. However, the railways are stating, we are not required to provide you any of
No,
this.
but your case is different. Your case is that from the station where the goods were uploaded to the destination station
Yes,
does not fall within the
50 good shades.
50 good shades.
specified. My lord, that is one angle. Another angle is the facilities, my lord. There is lack of facilities. They are stating in the WS, they are stating we are not required to provide you all the facilities. It is not mandatory upon me. I can still impose terminal charges. Third point of argument is, my lord, section 199, my lord. My lord, that it has not been passed by both house of the parliament. The railway, my lord, the railway has in 2007.
What has not been passed?
The rule for terminal charge, my lord.
Which rule?
My lord, exactly, my lord,
There is no rule. Railway says that it has imposed terminal charges in exercise of its powers under section 30 of the Railways Act.
Yes, my lord. My lord.
Now,
section-
whether rules are to be made for imposing charges.
Yes, my lord. My lord, because this is a new charge, a new rule being brought by the railways for imposing terminal charge. Section 30 is only empowering the railway to fix the rates, my lord. And railway, by bringing this new rule, my lord, railways are incurring thousands of crores of revenue every day, my lord, from all over India. In some stations, they are not imposing terminal charge. In some, they are imposing terminal charge.
No, that question is pertinent, whether terminal charges can be imposed only on the specified 50 station. These 50 stations are all over India or only for Northeast?
All over India, man.
All over India, only 50
Yes,
stations.
my lord, because only this 50 station have the this facilities, my lord. And zonal wise, my lord, central is central, Eastern Railway, East Coast Railway, Northern Railway. The zone wise, the stations are been mentioned. That only these 50 stations from the zones are been mentioned, that these have facilities of terminal charge such as crane facilities. And because of these facilities available, the railway are imposing charges, terminal charges, my lord.
Which section provision empowers the union government to fix rates?
Section 30, my lord.
30.
Power to fix rates, my lord.
Okay, anything else?
My lord, just this is my case, my lord. I have provided the judgment. passed
Where
by-
where is the impugn order?
My lord. Page number 24, my lord.
Twenty.
24.
There are many parties.
Yes, my lord. In fact, the tribunal has been is dismissing the claim for terminal charges on a regularly. It has been dismissed, my lord. 39 cases has been dismissed altogether.
Your original application number was?
268 of 2012, serial number 1.
Where it has been mentioned in the impugn judgment
In regard to my lord per incurium, my lord.
in para 3.
My lord, the findings in regard to terminal charge starts from page number 69.
60,
69 of the appeal.
it is a long judgment.
Yes, my lord. If I may read, my lord.
Yes,
He stated, as we specified earlier, the main contentions of the applicant in all these cases are that the originating and destination station are neither enlisted as terminal goods sheds in Annexure 1 of the Railway Board Circular dated 5/6/2007, nor having terminal facilities as enumerated in para 3 of the above circular. Moreover, there are also not notified as railway terminals having facilities in terms of Railway Board Circular. Therefore, the rate circular relating to terminal charges are not applicable to those rule goods shed. However, the applicant have fairly admitted that all these goods shed for which they have been charged unless under rate circular of the terminals are railway owned goods shed and controlled and managed by the railway for more than last 20 years. The buttress their claim, the learned counsel of the applicant has referred to MFA 42 of 2017 Union of
to
India.
this one,
Yes, my lord, the judgment which I placed. It has been declared as per incurring by the learned tribunal.
yes.
Further, my lord, in next para, apart from the above, the learned counsel of the applicant has also relied on the circular dated 17/7/2007, by which it was clarified and explained that the commodities packed in bag, can, carton, drum, bale, or crate do not attract liability of terminal charges, and stated that the consignment of the above case is packed in bags. He further asserted that as per the information received under the RTI Act from the Railway Board, the above Railway Board circular is still not withdrawn. That means 5/6/2007 is still effective, my lord. Further, my lord, per contra, the respondent contended that the above Railway Board Circular 5/6/2007 is meant for development and upgradation work of enlisted 50 railway goods sheds with the facilities in terms of para 3 of the above circular, for which the concerned railway administration were directed to prepare cost work as per the given guidelines and submit the same to the railway board. It has no concern with the levy of terminal charge on railway goods shed, which was first levied through rate circular dated 29/5/2007, prior to above railway board circular, by which all bulk and loose goods from and to railway goods sheds were brought under levy of terminal charges. Subsequently, the rate circular number 58 of 2007 was partially modified as rate circular number 74 of 2007, dated 19/7/2007. For clarification of the same, the railway had issued circular number 17/7/2007, by which it was clarified that the terminal charges would be imposed only on bulk and loose goods and commodities packed in bag, tin, carton, drum, bale, and crate, and do not attract liability of terminal charges. On the same way, it is also clarified that private siding is exempted from the liability of terminal charges. By rate circular number 92/2007 of 2007 dated 18/9/2007, the above circular number 58 of 2007 dated 29/5/2007 and 19.
What is this 92?
18/9/2007, my lord. I have next. At page number 99, my lord. The circular.
Okay, read,
If I may continue reading.
please.
Exempted from the liability of the terminal charges. By rate circular number 92 of 2007 dated 18/9/2007, the above rate circular number 58 dated 29/5/2007, dated 19/7/2007 were superseded and new categories with the new rates were introduced for terminal charges, my lord. This rate circular number 92 of 2007 recategorized the traffic for the purpose of terminal charges as iron ore traffic, other traffic, container traffic, fixing the rates of the terminal charges per terminal rupees 40, so and so, My lord, all other traffic, the rates are being mentioned in this paragraph, my lord. My lord, the relevant portion in regard to this MFA 42 interpretation in respect to MFA 42. Starts from page number 77, my lord. The High Court judgment interpretation.
Page number
77, my lord.
yes.
Para 34.2.17, my lord. Moving further, we notice that MFA number 42 of 2017, Union of India and two others represented by the general managers so and so, it appears that the applicant deliberately desisted to refer the case law on this point containing MFA 100 of 2011, Union of India represented by the
What is 100 of 2011? First read this para, 34.2.6.
and which also referred by the applicants, next page, my lord, and which also referred by the applicant before this tribunal is almost all the cases and well known about the above case law, as it is noticed that before this tribunal, Shri K.P. Maheshwari, advocate, is a lawyer in almost all the cases on behalf of the applicant, contesting and arguing the cases. And it is so because there is no reference to MFA 100 supra in the judgment of MFA 42 2017. If the judgment of MFA 100 2011 has been referred in MFA 42 2017 before the Honorable Court, an elaborate judgment on this point in dispute with binding ratio might have arrived at. Now, placing all the respect at our hand to the Honorable Court, it appears to us that the rule of per incurium is fully applicable in respect of the judgment of MFA 42 2017 on the relevance and applicability of Railway Board Circular 56 2007 to terminal charge, my lord.
Okay, just before that, you read the earlier paragraph where 100 has been discussed.
My lord, the para 34.2.16. 17.
34.2. Where it has discussed MFA 100 in this judgment also somewhere.
Yes, my lord.
34.2.13, page 52.
It is stated both these issues came up for the consideration before the single bench of Honorable Guwahati High Court in MFA 100 2011. Union of
No, read one paragraph before.
34.2.12, my lord. My lord, page number 75, 34.2.13, para.
Okay, read.
My lord. Both these issues came up for the consideration before the single bench of the Honorable Guwahati High Court in MFA 100 2011. Union of India represented by the General Manager, NF Railway Maligaon versus the Meghalaya Cement Limited. And my lord, the relevant portion has been extracted after, if I may read, my lord.
Yes, please read.
After careful perusal of the aforesaid letter dated 5/6/2007, it does not transpire that before imposing the terminal charges, it is mandatory to have such facilities as desired as per the letter dated 5/6/2007. The facilities mentioned in the letter is desirable and not mandatory to hold that for imposing terminal charges, such facility is required to be complied with. Be it mentioned that prior to issuance of the said letter dated 29/5/2007, the central government has accorded sanction of levy of development surcharge and terminal charge, my lord. Next para, further, it is not disputed that Changsari terminal shed is emphasis applied, my lord. This is in fact going in favor of me, this para. Further, it is not disputed that Changsari terminal shed is owned by railways and its rate circular number dated 18/9/2007 in terms all other traffic. It includes the terminal charges levied on all traffic except container traffic. As such, the railway department have rightly levied terminal charges in the judgment order dated 1 July 2011 passed by the member technical in claim application number so and so is liable to be set aside and dismissed, my lord. My lord, in this second para also, the Honorable High Court have held that since Changsari station also falls within this stations, my lord, it is not disputed that Changsari terminal shed is owned by the railways, my lord. It falls within the 50 stations, my lord. In my MFA 42 is speaking about 5/6/2007 circular, my lord. And MFA 100 is speaking about the facilities, my lord, whether the facilities are mandatory or not. MFA 100 is only in regard to facilities, not in regard to this 50 station, my lord.
We read next in para 9.
In para 9 of the judgment, Honorable Single Bench has also held that as per Annexure A1, the rate circular number 58/2007 dated 29/5/2007, the Railway Board levied the terminal charges for bulk and loose traffic on railway-owned terminal siding, ₹10 per ton. Therefore, thereafter, while the circular number 74/2007 modified the railway terminal charges ₹40 per ton per terminal in respect of all iron ore traffic, keeping all other condition of circular number 58 remain unchanged. Therefore, in separation of the rate circular number 58 29/5/2005 and rate circular dated 19/7/2007, the railway had issued the rate circular number 92 of 2007, which shows that though in earlier circular mentioned above levy of terminal charge in respect of bulk and loose traffic, but in rate circular dated 18/9/2007, in term of all other traffic is included and the terminal charges levied on all traffic except container traffic. My lord. It is in regard to, my lord, bulk and loose commodity tagged on that. My lord, in the subsequent paragraph, the MFA 42 has been declared as per incuriam by the tribunal. On the ground that MFA 100, that there is a judgment of MFA 100. However, both are totally different and do not have any correlation. In fact, MFA 100, my lord, the Changsari station is the notified station under the 50 boot shed.
MFA 100 also relates to imposition of terminal charges.
Yes, my lord, only in regard to whether the facilities are mandatory or not before imposing. And our Honorable High Court have held that facilities are discretionary and not mandatory for the railways.
Where is the list of these stations?
Station. My lord, PN number 92,
Where is Changsari?
my lord.
Okay,
My lord,
Okay.
NFR. New Jalpai,
Guwahati and Changsari.
in NFR,
Okay, so the facts are different in that case.
it's only, I have provided the judgment, my lord. This MFA 100 is only in respect to facilities has to be provided 5/6/2007 circular, whether facilities is mandatory or not. It is not speaking about whether the 50 stations, railway can impose terminal charges apart from the 50 station or not. And in this judgment, the Honorable Court has held that since Changsari is a notified railway station, my lord, that's why terminal charges will be applicable, even though the facilities is not there. And our MFA 42 and 105 is speaking, it can only be imposed in 50 sheds, my lord, and SLP was dismissed by this.
Yes, Ms. Devi. His main contention, what I have understood, is that terminal charges can be imposed only on those 50 stations which are developed as freight terminal, freight railway terminal.
But the fact is, like,
Apologies, my lord, for the interruption. Just one last thing, which. My lord, this is the extract from the Supreme Court website, which I've taken out at the time of this matter was put up. And my lord, if your lordship may look upon the back side, MFA 100 has been referred to. Similarities, nowadays Supreme Court website, my lord, the other judgment which are similar are also been given, my lord. Similarities based on state bench, and my lord, MFA 100 has been mentioned, judgment. It has been duly placed before the Supreme Court, my lord.
Okay. In which para the tribunal regarded the judgment in MFA 42 as
Referring to the,
referring to
my lord, at
page 79, Lord. Second para. Found at a law laid down in MFA 100 is much earlier in time with sound ratio and
yes, my lord.
delving into the extent railway board circulars and red circulars, while
The
in
later
MFA
judgment being
Lippmann-
per incurium as well as not loaded with tangible ratio, but on the proposition without any query. That's why herein it is stated we are bound to follow MFA 100, my lord. However, MFA 100 is not speaking anything about 56/2007 circular about the 50 good check.
And it was held that the Honorable Single Judge has no occasion in the, to delve into the applicability of the extant railway board circulars, red circulars in respect of terminal charge in MFA 42.
Okay, now what is the submission?
Lordship, their only claim is that, as per the, this is not even a circular, Lordship, 56/2007. This, Lordship, by this communication, they have identified 50 railway station as terminal station, and only in these stations, Lordship, they can levy search, terminal search. Well, if Lordship, page 89, Lordship.
Yes.
May I read, Lordship?
Yes.
Here the subject is development of freight terminals. In pursuance of Honorable MR's announcement during budget 2007-2008 regarding development of freight terminals, a meeting was held on 16/4/2007 with city PMS of zonal railways, in which 50 goods sets were identified for upgradation, Lordship. It is specifically said that it is identified only for upgradation, not for identifying it as terminal to levy terminal charges only in this specific railway station, Lordship. Thereafter, these are the developments that they will, Lordship, undertake. And next, Lordship, para 6.
Yes.
Para 6. A committee of senior DCM, senior DN, so and so of the concerned division should inspect the infrastructure existing in the goods sets and quantify the requirements to prevent over or under provisioning of works. Next, zonal railways must exercise utmost care while preparing the estimate so that cost of work is kept to an absolute minimum. If this is done, it shall go to a long way in taking up more such works in future. 8 Lordship, this is important. Zonal railways should move proposal for development of goods sets and submit them to board for inclusion in the supplementary works program by 30th of June 2007. Zonal railways should ensure compliance of the time limit. This issues with the Conference of Finance Officer and it was issued by Executive Director, Planning Railway Board.
What was the deadline for,
Deadline was 38 June 2007.
and when the terminal charges were imposed?
The terminal charges was imposed before that by the circular page 97 Lordship, 29/5, May 29, and this communication was for upgradation, it was of 5/6 June.
But
It was
that
of
came
June.
into effect on 1st of July 2007.
Uh,
Whether before 29/5, any terminal charges were imposed? No,
No Lordship.
this is the first circular
This is
by
the
which
circular Lordship. As per
terminal
the,
charges.
Tribunal's judgment also, this is the first circular imposing Lordship terminal service.
Okay.
And this is as per the central government, this is sanctioned by the central government. And it is by the Director of Traffic Commercial Rates. Lordship, he is the appropriate authority to Lordship levy search or all this Lordship. And this 5/6 communication, it is by the Executive Director Planning. He is not on this terminal charge or everything, all this Lordship. So this was this circular of 29/5 was applicable with effect from 1/7. And as per 5/6, the proposal was to submit by 30th June. It was for proposal Lordship. And it is not for identifying it, upgrading it as a terminal search Lordship. It is for upgradation for development of freight terminals. This is one Lordship. And in this regard, Lordship, the learned tribunal has also specifically discussed this issue, Lordship, at page 73. Page 73, clause 34.2.11. May I read this, Lordship?
Yes.
The above extracts of relevant Railway Board circular and rate circular show that Railway Board circular number so-and-so dated 5/6/2007 was not issued by the Director Traffic Commercial Rates of the Railway Board, which is solely entrusted to fix, vary, or create freight charges, new charges, but by Executive Director Planning of the Railway Board, who is responsible to sort out plan for developmental work in the Indian Railways. In the above rate circular, though the subject is shown as development of freight terminals, but the chosen 50 stations referred as goods sets and not as freight terminals. Further, it stipulates only.
What is the difference between freight terminals and goods sheds? Same. Freight means goods. Is there any difference between freight terminal and goods?
Sets. Goods sets, most probably lots of where the goods are stored, lots of.
Freight terminals? What is the meaning of freight?
Sir,
Freight
where the
is the
SARS
charges
where
for
the
carrying
SARS
of
can
the-
be
No.
imposed.
See the dictionary. Yes, you continue. Let him see the dictionary.
That's it. Freight terminals, but the chosen 50 stations referred to as goods sheds and not as freight terminals. Further, it stipulates only planning for development and upgradation of above 50 goods sheds as per norms given in para 2 of the circular and with the facilities given in para 3 of the circulars for which a draft plan was.
One thing
for.
is clear,
Yes, Lordship.
that the notification which says for upgradation of some good shed as freight terminal
It does not fix the
specifies a date of which it will come into effect.
proposal submitted.
Uh,
It is for submission of proposal, Lordship, page 90. Zonal Railway should move proposals for development of goods sheds and submit them to board for inclusion in the supplementary works program by 38 of June 2007. Proposal has to be submitted by 38, was to be submitted by 38 June 2007. It was not an effective date to
Okay.
it is only for submission of proposal also. And also next also, this railway board circular does not give any indication that it relates to terminal service by any way, but just confined to development of freight terminals with facilities. In fact, terminal charge along with development surcharge was levied for the first time by Red Circular 58 of 2007, dated 29/5/2007. Prior to the above railway board circular for development and upgradation of facilities on freight terminals. In this Red Circular dated 29/5/2007, para 2, terminal charge was levied on loading and unloading terminals independently and separately on only bulk and loose goods at the rate of ₹10 per ton per terminal. The words railway owned terminal.
Otherwise, for uploading, what other charges are imposed?
Apart from, sorry.
Suppose terminal charges are removed,
Yes, ma'am.
what charges you have to pay for?
Development charges, my lord, the freight are being imposed. So my lord, the definition of the freight which your lordship just read, my lord. The
Yes.
meaning of the freight has been given as goods transported in bulk by truck, train, ship or aircraft.
So it is goods,
Yes, ma'am.
it is not charges,
My lord, freight terminals.
goods terminal.
Yes, my lord. My lord, I'm.
No, you answer.
Yes, ma'am.
For booking a consignment of goods to be carried by railway from one station to another, what do you have to pay?
Such freight means the charge levied for the carriage of goods, including
It has been defined,
if any.
dictionary meaning, defined.
Classification of Railway Act 1989.
Okay. Section,
Let's say, section 2. Section 2, subsection 17.
then by that definition, you can levy charges only on these 50,
That's it.
because these are developed as freight terminals.
Freight terminals, only development purpose, let's say it was not notified that this 50 will be used only for the, for import levy of terminal.
Before this levy of, before this 2007 notification,
2007.
by which terminal charges were imposed, what the customer had to pay for booking his goods? Had this charge not been there, what you have to pay?
Only the freight, my lord. Only the freight which was supposed to be for transportation.
That freight is as per,
As per there's a railway schedule, my lord, there's a calculation, the classes are mentioned as per the goods classes, their distance. My lord, the calculation of rate has been done, there's a slab. So my lord, there's a class 100, 150, 120, 110. So in which class the commodity is falling? There's a distance slab, my lord, 100 to 200 kilometer, 200 to 400, 600. So in accordance to the distance, the rates has been mentioned. And in accordance to the weight of the consignment also sometimes, depending upon the goods, this calculation of rate has been done. This is totally a new charge brought in 2007, my lord.
Lordship, in the circular dated 29/5/2007, there is no condition that in order to impose the terminal charge, Lordship, it has to be upgraded or any special facility has to be given, only then they can search the terminal search. And also this circular is not under challenge, Lordship, at any point of time. From 2007, they are paying terminal search on the basis of this circular. Now, Lordship, this fact is also, Lordship, not before the tribunal, maybe. For the first time, this circular has been challenged in this appeal.
My lord, this
Yes, please continue.
So, Lordship, and it is, and they mainly rely on the Honorable High Court's order, Lordship, which has also been clearly discussed by the learned tribunal, Lordship. That without considering the different circulars.
I'm which will have any persuasive force. The tribunal is under scrutiny of this court, tribunal's order. We are scrutinizing it in appeal. And the coordinate bench judgment has a binding effect. Binding at least have a persuasive effect. If I binding effect in this sense that I have to otherwise follow it. If I differ, then I have to refer the matter to a larger bench. I cannot differ.
But Lordship, they have simply relied on this 5/6 communication of 5/6 2007. This nowhere stated that these are not exclusively not these 50 stations are exclusively notified for terminal.
No, this complete reading this paragraph.
Which one, Lordship?
34.2.11. From but just confined to development of freight terminal.
That it relates to terminal charge by any way, but just confined to development of freight terminals with facilities. In fact, terminal charge along with development charges was levied for the first time by Red Circular 58 dated 29/5/2007. Prior to the above Railway Board circular for development and upgradation of facilities on freight terminals. In this Red Circular dated 29/5/2007 by Para 2, terminal charge was levied on loading and unloading terminals independently and separately on only bulk and loose goods at the rate ₹10 per tons per terminal. The words railway on terminals and sidings are used in this circular. It means that the terminal charge is to be levied on terminals and sidings. Since this circular does not stipulate for having prior facilities referred in Railway Board Circular number 56/2007, therefore the applicant's assertion that railway terminal goods sets would attract liability of terminal charge only if they have facilities referred to in Para 2 of Railway Board Circular dated 5/6/7 is totally misconceived and could not reasonably be inferred by reading the above circular simultaneously. Red Circular number 2092 of 2007 dated 1897, whereby previous rates of
You may have some water.
sorts. Last line, Lordship, it clearly demonstrates that levy of terminal charge has no connection with Railway Board Circular dated 5/6/2007.
Okay, that was the reasoning.
Yes, Lordship.
And that is your submission also.
Yes, Lordship. Because it is nowhere stated in this circular, Lordship, that this terminal charge will be levied only on this identified 50 railway stations. It
And what
only
is your s-
proposed to develop
Oh,
these
okay.
railway stations, Lordship.
Okay, what is your submission regarding,
And it has nothing to do with the levy of terminal charges.
what is your submission regarding MFA 42 of 17?
42, Lordship, the terminal has
Because this court,
discussed, Lordship, that without considering the different rates and circulars, the honorable court has passed this order. Therefore, it is not, Lordship,
it has been upheld by the apex court. Apex
42, Lordship.
42, because you preferred an appeal against, you preferred an SLP which was not admitted, it was dismissed.
In this case, Lordship, I have to take exception.
You have a copy of that order?
Yes.
Give it to them.
My lord, Supreme Court has considered MFA on that I've given.
Yes, any other submission?
Because their claim is only on the basis of this 5/6/2007. The other issue regarding the legality of 2007 rates circular, etc., these are now they have brought this in their appeal. Their only claim is that as per communication dated 5/6/2007, these are identified station on except this station, they cannot levy terminal charge on other stations. This is not a fact, Lordship, as per circular dated 29/5/2007. Nothing has been said, it simply says that this, yes, prior to Lordship, sanction of the central government is also accorded to the levy of terminal charge of ₹10 per ton per terminal. These terminal charges will be levied for bulk and loose traffics on railway owned terminals and sidings and not on terminals owned by customers. So as per the railway circular dated 29/5/2007, the only condition is that it should be railway owned terminals and sidings and not the terminals owned by customers. So these are still holding the field loss in these circulars. Therefore,
No, this question was specifically formulated by the court in MFA 42, whether terminal charges can be levied for all stations. And it was answered specifically by the court that it can be levied only for those stations as mentioned in the
50 good shed, which has been developed as terminal.
terminals. And the railways have preferred an SLP against that also.
is supported by, let's say it may be fixed on Tuesday, Lordship, for final disposal, Lordship. I will take it instruction or I will go through it, Lordship.
Question of law.
Yes, Lord. Whatever may be.
Okay.
Only question of law is there, my lord, and my lord.
No,
Because this Lordship circular is still in force, Lordship, 29/5/2007. Here, no condition has been imposed that only on developed terminals or anything station, this charge will be imposed. It simply said that railway terminals and settings, the terminal charge will be imposed, not on the private terminal, not on private Lordship terminals.
no, you have to answer two questions.
Yes, sir.
When
No.
this court has specifically held
42.
in 42 that specifically answered the question formulated by it,
Mm.
that when the, okay, I'll reflect it in my
That's it.
in my
Order.
order. It will be helpful for you. Heard Mr. D. Rathi, learned counsel for the appellant. Also heard Miss
R.
R. Devi, learned central government counsel. Though learned counsel for both the parties were heard at length, a question was posed by this court that when in MFA number 42/2017, this court, a coordinate bench of this court, has specifically formulated a question to be answered in that appeal. That is, within inverted commas, whether railways can levy terminal charges for loading of goods in all stations, and answer that query answer the said question in paragraph number 10 of the judgment in answer the said question in paragraph number 10 as follows, within inverted comma, as follows. Para 10, quote para 10 from the judgment in MFA number 42/2017. Yada se quote kori. Further, it also appears that no, under such circumstances, ki production. No, whether as follows, under such circumstances, whether it was open for the Railway Claims Tribunal to take a different view by holding the aforesaid judgment as per inquirium. Stop. Moreover, it also appears that the railways, the Union of India had preferred a special leave petition, which was special leave petition bearing diary number 40703/2024 against the judgment dated 9/4/2024 passed in MSFA number 42/2017, and the said special leave petition was dismissed by the Apex Court by its order dated 21/10/2024. Stop. Under such circumstances, whether the judgment rendered by the coordinate bench of this court in case MFA number 42/2017 would have a binding effect on this court in this appeal. Learned Central Government Standing Council prayed for some time to answer the aforesaid queries. Thursday, let this matter be listed again on 18th of December as part heard matter.
My lord, MFA 105, there's two judgment. MFA 42 of coordinate bench, two judgment is there. MFA 40.
No, 105 is different. It relates only to specified. Oh no, 105,
Two judgments are there. And for
but
MFA
105 has not been appeal, no appeal was preferred. SLP,
40, diary number 40703 and 40701, common order, quorum of three bench, my lord, Supreme Court, consisting of Chief Justice, my lord. Honorable Justice D.Y. Chandrachud was there. In fact, my lord, I was, a lighter note, I was in Delhi Supreme Court at that point of time when this matter was called.
no, where is the mention about 105?
My lord,
A separate order has been passed.
same order, my lord.
Where?
My lord, in the top, my lord, I'll just highlight and give me.
In the top, it is 42/2017.
Yes, my lord.
Then where is 100?
Um, 42, Union of India, Eastern Bhutan.
It is not there.
My lord, diary number is there, 40701. I'll place the record, my lord, in the next video. 40701. Another diary number is there, my lord. With connected with, it has been mentioned. With,
But no mention about
Yes,
MFA.
but that
my lord, I'll produce the details of this in the next video.
List it on Thursday. Meeting.
My lord, just if the railway can seek an instruction whether a terminal rule has been passed under 199, if that can be done, my lord.
this is not their case, lordship, and,
I've said that, made this submission, tribunal has
because
considered
they have not.
section 30 is power is there. So I
They
have
have not
pleaded-
challenged the
Okay.
legality
No,
of this,
let
circular, lordship.
let them answer according to. That is not required.
Lordship.
I'll address your submission.
So they have not challenged the
rule-
legality of this circular.
The terminal rule has been imposed by way of this circular of 2007, 29/5/2007 for the first time. Whether any rules have been framed for imposing this
Circular.
terminal charges, you can find out. Is there any rule or whether it has been imposed by the circular only?
As per section 30, lordship, the central government can.
Yes, you can make your submission on that day. Whether section 30 empowers to impose a new right, new charges in the form of terminal charges. You can also make your submission on that.
and be clear on that.
Same,
Yesterday.
Anything to say?
Yes, yes, I have not
Sir.
pressed my grounds only. Whatever simple case I have, I will have to press, but if your lordship is willing to take up at the this hour of the day.
actually, I am not willing. But how much time will you take?
My lord, I have the simple case, I have already placed
will be
my
taking some time
written argument as well as the citation of the authority I have to rely upon. So that they also said that this ingredients of
Your lordship
quality
can
is
take up
not there and
tomorrow also, your lordship, please.
one,
Because this is the last, only the last.
Kali kiman ase ki? Tomorrow we'll take it up at 2.
tomorrow, my lord, I'm sorry, my lord, then I have some other application in tomorrow.
Day after tomorrow,
Day after tomorrow will be Saturday, my lord.
on Monday at 2.
Mon-
Monday at 2. Monday or Tuesday at 2.
Ah.
Though it is motion day. After motion matters. Motion day is fixed, but we may not have so many motion.
Yes.
Okay. Please, heard so. Heard Miss Idas, learned counsel for the appellant. Also heard Mr. M.J. Borra, learned counsel for the respondent. Place this matter as part heard matter on Tuesday is 16 for further hearing at 2 p.m.
Obliged.
Deeply obliged.